Contempt petitions memo, my lord, it could be taken for long time. It has not been listed.
Have a patience, it's listed.
So, any trade, my lord.
Wait till- No need to submit a memo, it will listed. Office objections removed,
Sorry, my lord.
objections are removed,
No, it's a old man. Notice has been issued, my lord. It's already.
then
It's a
some
old
date,
matter.
it
Please.
must be given, some date must have
Not
been
given.
given.
It has not
Not
listed
given.
for 8 to 6 months. So,
Alright.
that's it.
10th, 5th of July.
Please.
My lords
My
and
lord, writ appeal, my lord. My lord, writ appeal, fresh matter, my lord. Here there are about 200 outlets are being closed, my lord, for no fault of them, and there are hundreds of people there be deprived of their livelihood, my lord. This is a case pertains to the herbal hookah. Herbal hookah, my lord, the batch of
Deprived
petition,
of what?
my lord,
Deprived of what?
deprived of livelihood, my lord. The employees who are working the outlets, they are being deprived, my lord. This petition is different from the other petitions. It is in the batch of
Every petition is different from other petition.
it is in the batch of petitions. I was also suffered.
That you know or not, every petition is different
Please, my lord.
by
Some
itself.
urgency, my lord.
No,
my lords, a humble submission.
by it will come. You file or remove the office.
We have
object,
already filed, it is clear.
Then it will be listed within no time.
Kindly,
Yes.
serial number 9 and 13, Lord, arguing counsel is unwell. Lord, serial number 9 and 13, my lord, arguing counsel is unwell today. I've informed the
9
other
and
side.
13.
Lord, I appear for appellant in both the matters, my lord. I request.
My
for
lords, I
some
appear on
time.
behalf of the respondent number 2 in serial number 9, my lords. Since we have no objection since the arguing counsel is not well, a date may kindly be fixed. my lords.
When do you want both of you?
Appealing for the respondents in seal.
My
Madam,
lords,
when do you want
Lord,
both of
2
you?
weeks, any date.
2 weeks, 10th July,
10th July, my lords, please.
9 and 13 both,
13 and let's say this.
9 and 13 both.
I
9 and
appear.
13 both.
My lords, in humble submission, my lords.
Serial
My lords,
number
humble
26,
submission, my lords. The serial number 66, my lords. The
Serial number?
matter, serial number 66, my lords. The
16,
66.
66.
My lords, the matter has been appearing all the time in 60s and it has never come up before this honorable court, my lords. It's a mere matter of dismissal, my lords. This writ appeal kindly be taken at 1:30 or 2:30, my lords.
It never comes up.
No, my lords, always
Date-
it.
Today it has come up.
Today, again, it is always at 66, my lords, because of paucity of time,
66.
it never reaches this
66
before the
will not
honorable.
reach.
No, my lords.
Who said that?
My lords, I've always come before the honorable court, but it has always not reached serial number 66,
So
my
that
lords.
is a matter of past. Now it will reach.
My lords,
Wait,
kindly,
wait.
my lords, only matter of dismissal, my lords, at 1:30 or 2:30.
Let us see, it will reach. It doesn't reach, then please mention after.
After, towards the end, my lords.
Reach. You are right.
My lords.
Not to be placed before the bench.
My
Serial
lords.
number 26,
One second. Not to be placed before the bench where one of us, into Honorable Mr. Justice K.V. Arvind, Bracketor, is a member. You are absolutely right.
My lords.
It will never reach before this.
My lords. That's not what I meant, my lords. Apologies, my lords, if I've not that it's a.
Nothing to be apologized. Yes.
Lords, file a memo for posting for this writ petition. The petition has become infructuous.
Which one?
The current writ petition.
Today it is notified.
Sorry, my lords?
It is notified today.
No, my lords.
You want to notify it
My lords, it had come before your lordships. We are filing memo for withdrawal.
tomorrow.
My lords, can be listed today, my lords, at 2:30. My lords, may it be listed today at 2:30.
Today. There is no such urgency for withdrawal. When? 10 July, you withdraw on that day.
My lords, kindly have it tomorrow, my lords. Withdraw the matter.
List.
serial number 26, my lord.
Why you want to withdraw so fast?
My lords, can be
Then you
listed.
can wait till 10th of July, since its date is given.
Tomorrow would be good, my
Why?
lords.
Why? But
It'll get done quickly.
you want to go abroad by after
No,
withdrawing?
my lords. My lords, tomorrow maybe listed 2:30.
Tomorrow, yes, Mr.
Tomorrow at 2:30 may be listed, sir.
Tomorrow at 11.
My lord.
Serial number 26, my lord.
Yes, 26.
My lord, is a contempt initiated for not considering representation. We will consider the representation and report complaints in 3 weeks, my lord. If it may be taken up on July 10th, by which time we will report complaints. It's for non,
Let it be called out,
My
not by
lord,
mentioning.
My lord,
please.
You can't mention like.
for
yes.
petitioner
Hello.
civil contempt, my lord. They have
Pardon?
City Municipal Corporation, they have not obeyed the Honorable High Court order, my lord. Fresh matter. And
Duly listed. No
Lots.
need to file memo.
Serial number 54, my lord.
76, my lords. Respondent number 7 to 11, my lords, have already approached Honorable Supreme Court. The SLPs are pending there, my lords.
It will adjourn
And for the
for
petition.
4 weeks.
I'm for the petitioner, my lord. In 76, my lords, I'm for the petitioner.
He is
my lord.
saying Supreme, it is
Yes, my
matter
lord.
with
Supreme Court has said to stay the hands till the
Serial number 54, my lords.
50,
I appear for the complainant in said matter.
54.
54, my lords.
What do you want?
If I may be granted 10 days time, my lords, I would like to produce some documents in that.
All grant.
Oblige,
9th July.
oblige, my lord.
Kind permission. Contempt matters, seal number 1, Mr. Sagar BB.
For the complaints council.
Notice returnable on
Yes.
19th July.
Please. Seal number 2, CH-1 Basuraj.
Complainants.
Yes, what is the contempt?
Contempt, my lord, page number 24.
24.
The Isamba Court, my lord, has directed the authorities to, my lord, avoid the decision by the deputy commissioner.
What is direction? Let us. What is to be complied with?
My lord, they have the proceedings, my lord, initiated against the
To show the
petitioners. my lord.
direction of law in a single judge, which can be complied with in contempt jurisdiction.
Yes, please, ma'am.
Where is that?
Page number 24 may kindly see, my lord.
Read.
Having regard to the facts narrated herein above, this court is of the considered opinion that the Tahsildar will have to avoid the decision at the hands of the deputy commissioner in RA number so and so so on. My lord, in page number 25 may kindly see, my lord. They have put the board saying that, my lord, the land is, my lord, belongs to the government land. It is a tank
Must
bed
be a
area.
clear direction.
Please.
Where is the clear direction? What is to be done by them under the orders of the court, which we can enforce in the
Since, my
contempt
lord,
jurisdiction?
proceedings before the deputy commissioner, my lord, it is not yet been, my lord, completed. The Tahsildar, my lord, instead of
Operative
yes,
directions in
Tahsildar
the
is
order.
also
There is no
Tahsildar is
direction which can be brought under contempt jurisdiction. You
Is
file
it-
whatever
no.
proceeding.
What is the problem is, my lord, we are facing, my lord,
We
we
are
are
not here to solve the problems.
No, no,
We are
no.
here to enforce
by
the
putting
orders of
this board, my lord, they are not, my lord, allowing us to carry out the agricultural activities, my lord. They are
Why don't you understand? There is no direct direction. There is no positive direction which can be enforced in the contempt jurisdiction.
eviction notice have been quashed by this court,
There
my
is
lord.
the-
After quashing the notice, my lord, this court has observed, my lord, in paragraph 24. Before that, my lord, eviction,
Where
the
is it?
eviction notice, my lord, have been challenged before this court in the writ petition. Consequently, my lord, the para 5 of the writ petition may kindly see. Accordingly, the writ petition has allowed while setting aside the impugned notices annexure F, G and H, the Tahsildar Kolar.
So what is legal notice?
Evict the land, my lord.
Then there must be direction of the court to implement the notice.
My lord,
Merely your sending notice will not attract the contempt
eviction
jurisdiction.
notice have been issued, my lord, against the petitioners. That has been called in question in the writ petition.
Whoever
By
you
quashing
may have
the
different
quashing the
remedy.
notices,
You may have different remedy, but not the contempt.
my lord, my submission is, my lord, after quashing, my lord, the
Basic requirement to exercise the contempt jurisdiction is that there must be a positive.
yes, please, my
direction.
lord, my lord, they have
Is that positive?
what they have done is, my lord,
There is no direction, much less positive direction by law on a single judge.
my lord, the clear direction, my lord,
You can-
avoid the decision of, avoid the orders from the deputy commissioner. My lord, instead of, my lord, avoiding, they have put the board, my lord, in front of the lands,
That
and
may-
my lord, they have treated us as a trespassers.
Those may be your facts, but not the direction.
My lord, unless and until, my lord, we cannot enter into the land, my lord, to agricultural activities. This is the whole problem we are facing. Though we have, my lord, brought to the notice of the authorities, though the eviction notice have been quashed by this Honorable Court, and the authorities are directed to avoid come of the deputy commissioner order. My lord, they have put the fence, my lord, they have put the board, and my lord, we have prevented, my lord, entering to the land as a trespasser. We are the public, my lord, these lands, my lord, have been auctioned by the government way back in the year of 1927. We are the auction purchasers, and the land has been converted.
Where is your writ petition? Where is your writ petition?
Writ petition, my lord, I have not produced, but notices, my lord, I have produced the notices, my lord. Annexure A. I have produced the notices at annexure, my lord, A. Eviction notices.
No, where is your writ petition?
Writ
Produce your
writ petition I have not produced, my lord. I will produce, my lord.
You produce, then we'll consider.
Please. Monday, my lord. Much obliged.
December 3, Mr. Sampath.
For complaints, please.
Notice returnable.
Please.
19th July.
Number 4, education
My
matters.
Lord, I appear for the
BP
petitioner.
Negre.
Lord, petitioner number 1 is a MBBS student, petitioner, who's studying, my lord, in the petition number 2 college. Now, my lord, your lordship may kindly, my lord, turn to page 33, my lord, annexure H. We are seeking, my lord, for approval of the admission.
30.
Approval of the admission, page 33, my lord, annexure H.
That is some.
My lord, this, my lord, is the Karnataka Examination Authority. Initially, my lord, this girl, my lord, one Teja Krishna Sri, my lord, was given the seat in the petitioner number 2 college, and she had to, my lord, come to the college and get admission. It says, my lord, the candidate is directed to report to the principal of the above institution by 11/11/2023. My lord, she does not do so. She does not appear, my lord, and take admission. For the admission to the college, the Supreme Court, my lord, had put a cutoff date as 15/11/2023. Therefore, my lord, we brought to the next page, my lord, is the mail, my lord, returned to the KEA. Bringing.
So she is attending classes.
My lord, she is not the petitioner, my lord. She is some other candidate who was given by the KEA admission to this college.
She's paid 33%.
Pays 33%.
Yes.
But she never turned up, nor she took admission. Though, my lord, my admission, my lord, is for 150 students. 149 were admitted. One student, my lord, the KEA did not send any students. Therefore, my lord, we wrote a letter on the same day on page 34. Your lordship may kindly see, my lord, page 34.
You are a petitioner.
Yes, my lord.
There is by petitioner.
By the petitioner number 2, my lord, that is the college. It is to the.
Here, who are the petitioners?
My lord, petitioner number 1 is the student who's now been admitted. Petitioner number 2 is the college, which has
now admitted to this college.
This same petitioner number 2 college.
Now they are not permitting to sit.
Yes, my lord, they are not approved the admissions of the MBBS course. Now, my lord, the exams are.
So cutoff date was 23rd of 11th.
My lord, cutoff date was 15/11/2023.
15th.
That is, my lord, to admit. And my lord, in the website by 22nd, we have to, my lord, give the list of students. We have done so, and we have, my lord, shown petitioner number 1 has the student who has already been admitted.
Where is that?
My lord, if your lordship may kindly turn to, my lord, page 42, my lord, is the list, my lord, which has been page 42.
No, that you must have mentioned at page 34 later.
Yes, my lord.
Let us see. Page 34.
Now, my lord, your lordship may kindly turn to page 34. My lord, this is, my lord, on 13th November itself. We have sent last paragraph, my lord. However, one seat is left vacant, and student SSM Teja Krishna Sri, who was downloaded the admission order number so and so, has not yet reported to the college as on date. Therefore, we request your good self to kindly look into the matter and allot another candidate as a replacement to fill the sole vacancy. Kindly do the needful in this regard at the earliest, since the same is bound by the due date. Regards. Now, my lord, your lordship may kindly turn to the next page, my lord. This is also, my lord, on the 15th.
Third learned advocate, Mr. So and so for the petitioner. The issue involved is about the admission of petitioner number 1 student to the course of MBBS UG seat, UG MBBS for the academic year 2023-24. the cutoff, the last date for admitting the students to the state course was 15/11/23. Paragraph. It was pointed out from the record of the petition, or more particularly from page 33, from the documented page 33 of the compilation, inter alia that. So the student, this lady student left.
My lord, she did not come, my lord, to take admission, though she was given it.
That the student named, what is the name?
My lord, SSM Teja Krishna Sri.
SSM, separate, SSM Teja Krishna Sri, SRE, who had sought admission to the course, did not turn up.
Within the last date, my lord, 11/11/23.
Not turn up till last date, and that she has not joined the course. So the petitioner was next.
My lord, petitioner was not next, my lord. Then, my lord, we requested, the petitioner number 2 college requested the KEA to send one student, my lord, to fill up the vacancy. They did not do so. On 15th, which was the last date, cutoff date, we sent, my lord, page 38. Your lordship may kindly see.
In the case of the petitioner number 2 college, that in view of the seat becoming available because of non-joining of SSM Teja Krishna Sri, the Karnataka examination authority was requested to allot a student, which however did not happen, and no student was allotted. Full stop. In full stop. Thereafter, it is the further case, that the petition number 1 approached the petition to college and sought admission by paying the necessary fees. Full stop. The admission was given. The college addressed letter dated
On 15th itself, page 38, my lord.
15th November 2023 to the Executive Director of the Karnataka Examination Authority, pointing out about where your name is.
My lord, that is at page 38, my lord. Your lordship may kindly turn to page 38.
Then in the page 34, you are mentioned not.
Page 34 was, my lord, bringing to the notice of the KA that the seat is vacant. Give us one more seat.
The factum about the seat having become vacant was intimated to the Karnataka Examination Authority by petition to college, by issuing communication dated, by sending communication dated 13/11/23 into bracket page 34, full stop. Figures at page 38 into bracket annexer K1 is the detail of the.
On the last day, my lord, we admitted the name is of the petitioner.
Petitioner 1 who had requested for admission, which was on the last day available for admission to student. Full stop. It is the further case of the petitioner that he is admitted.
She's admitted, my lord. She's attending classes.
But without permission of the KEA.
Now, my lord, KEA has not yet, my lord, approved or rejected. We have sent a mails to them to approve it.
The fees were collected from the petition number 1, and petitioner came to be admitted by petition to college. Full stop. According to the case, the Karnataka Examination Authority has neither approved nor rejected the admission. Full stop. Notice returnable on.
My lord, now, my lord, the urgency is the exams, my lord, will be held last date for.
You are coming at the last moment.
No, my lord, the examination, my lord, is on 9/8. To pay the fees, my lord.
This is November 23. We are in which month?
My lord, there, my lord, we have said. My lord, similar matters, this honorable court, my lord, has permitted, my lord, in the last year.
Similar matter, forget similar matter. Trust your argument and trust your court.
My lord. May I make one request, my lord? Pending dispute, my lord, let me.
Returnable on when the examination starts.
My lord, last date to pay the exam fees is 4/7, my lord.
4/7.
The exam starts on 9/8, my lord. 9/8. My lord, in the previous year, my lord, this honorable court, my lord, in the similar circumstances, in the same college, has permitted, my lord.
Returnable. We attended the classes.
My lord, not attend, my lord, to take part in the exam and declare the results also. This honorable court, my lord, has permitted. My lord, in the last year.
This student attended the class.
Yes, attending the class.
Notice returnable on. 5th, 4th of July 2024. Guessing the interim relief, it was submitted. That not only the petitioner one has attended the classes at the college, the next examination slated to take place on 9/8/24, and that the last date for payment of examination fees is 4/7/24. It was submitted that unless the appropriate interim order is granted, the petitioners will have to face an irreversible situation, and the fruits of the petition, if petition succeeds, may not be available to the petitioner number 1 student. In the facts of the case, by way of it is directed that the examination fee of the petition shall be accepted by the college. Put upon 4/7. We'll see on 4/7 first.
Right.
Will be accepted by the, who will be accepted? Respondent KEA.
Okay, my lord, your last my permit, my lord, I will serve on the standing councils also.
Respondent KEA. The petitioner is, the honored counsel for the petitioner is permitted to serve copy of this petition to the honored counsel who normally appears in this court on behalf of the Karnataka Executive Authority.
My lord, even the Rajiv Gandhi University I may be permitted, my lord, R3.
There you serve.
I'll serve, my lord, if your lordship permits, my lord.
Rest of the respondents will be served.
Yes.
You serve all so that.
Yes, my lord, I'll serve.
Give advance copy to the council.
Yes, my lord, I will do.
Number 5, the Suraj Sampat.
Lords, I'm a PG IU student, my lords. The course
What is the problem with you now?
Sorry, my lords.
What is the problem now?
My lords, I'm an OBC student, my lords. I take admission in December, my lords. I joined the classes in December. Suddenly, by Annexure A, my lords, in June, 4th of June 2024, they remove me straight away, my lords, without any notice or anything, on the ground that my score is below the requirement for NEET percentage. What I write is AIA PGET 2023, my lords, not even the NEET exam. But
AIA PG, what is AIA PG?
All India Ayush Postgraduate Entrance Test, my lords, 2023. All India Ayush Postgraduate Entrance Test. That's the exam written by me, my lords. In that, my lords, my marks card is at.
So that you are.
I get 37.78%, my lords.
7 point?
37.78, my lords. I am an OBC student, my lords.
Is above cutoff line in your category?
Yes, my lords. So what would happen? Initially, it is 40%. But Annexure D, my lords.
Your case is that they have mistaken the exam as NEET.
No, my lords. Their case is that I have taken the NEET and my percentage is lower. But actually,
NEET has nothing to do.
It has nothing to do with NEET. I have taken AIA PGET on the basis of my AIA PGET. They've given me admission, my lords.
Honored advocate for the petitioner, Mr. So-and-so. The admission of the petitioner student in the Panch Karma course came to be cancelled on the ground that the petitioner could not secure the minimum cutoff mark in NEET examination. Also, the petitioner has been pursuing the Panch Karma course for which it was submitted that the NEET examination has no relevance at all. Also, what petitioner passed was the All India Ayush Postgraduate Entrance Examination, in which the petitioner scored 37.78 marks. Also, the petitioner belongs to OBC category.
Yes, my lord.
Also, it was submitted that the marks of 37.78% secured by the petitioners is the marks above the cutoff.
As per Annexure D, my lords.
In the
page
OBC
25.
category. Also, this was sought to be fortified from. What is this?
This is the National Commission of Indian System Medicine, my lord. They've issued a notification. If I may just read, my lord, with reference to this.
Presented 9/11/23, figuring at page 25 in Annexure D. Notice returnable on which date?
My lords, I've asked for an interim relief to permit me to, because the internal assessment test starts now, my lords.
Yep.
In the end of June, my lords. Which is why this honorable court listed the matters also today, my lord.
When it is started?
I may be permitted to take those exams and attend classes in the
When
middle.
it is starting?
It's at the end of June because I'm not allowed to. I've been removed from the college, my lords. The dates have been put on the notice board, my lords.
So removed, we can't give the interim period.
No, my lords. It's on the ground that I'm below the percentage. As per the notification itself, I'm above the percentage, and they've chosen the wrong exam.
Tell the date of commencement of exam.
It's from my information, my lord, it's end of, it's as per the notification, my lords, at annexure E, my lords, page 27.
It was submitted at this stage by learned advocate for the petitioner that the internal assessment examination is scheduled to begin anytime in the last week of
June, my lord.
June 2024. Full stop in this view. In order to consider the, in order to enable the court to consider the question of grant or otherwise of the interim relief to the petitioner as prayed for, it is directed that the notice in this petition shall be returnable on 21st. Today is what, 21st of June. Full stop. Learned counsel for the petitioner shall supply copy of the petition to learned advocates, 2 and 3, who normally appear.
I've already served R3, my lords. R3 and R4 have been served, my lords.
R3 and 4 served, full stop. The learned advocate petitioner is directed to intimate the counsels for 3 and 4 who are already served.
R3 and R4 already served.
Remain present and asks the court on 21st.
21st.
Full stop.
Please.
On that day will consider.
Lord, the annexure E notification in the last sentence, my lord, point number 10 would say IA, internal assessment may be conducted once in every 5 months, 5 plus 5 plus 5. Page 27, my lords, annexure E. That lays down the schedule of events also, my lords.
In the meantime, the petitioner shall be permitted to undergo the necessary formalities, if any, for the purpose of appearing in the internal assessment test.
Please, my lord.
Whatever you want to do, please step towards.
Please, my lord. For that, I have to be only permitted to attend the classes, my lords, without the necessary percentage of attendance.
The words we wanted to say.
Yes,
it is for you and for the authorities in the meantime. Only 2 days question. We'll consider on 20.
Please. Much obliged.
Yes, next.
The PL matter, serial number 6, to Shyam Kumar SU.
So please, your lordship.
Serial number 6.
Lordship. Much obliged. No, but now I'm here. No, I appear here now regularly for the LSA only. Pardon? No, now I'm here. Now I'm in Bangalore. Or can it be Tuesday? My learned friend has a problem. Yeah, 26. Yeah, 26. Yeah. Much.
So green bench matters, serial number 7. Ravindra Gajanan Kolle.
Please, my lords.
6 months is over. Yes. The provision is, my lords, the wrong provision has been quoted. Exact provision is rule 6.4, but they quoted rule 5.4. Of course, I'm not on that technicality. Yes, the correct provision of law which they intended to take is rule 6.4, but I'm not on that point now for the time being, my lords. But my request is, if rule 6.4 is read, my lords, makes it very clear. The second sentence, my lords, the first sentence of sub-rule, the lessee or licensee shall remove or transport the minor mineral extracted from a quarry. There are two things. Sorry, my lords. Rule 6.4, sub-rule 4. The lessee or licensee shall remove or transport the minor mineral extracted from a quarry during the currency of the lease or license within 6 months from the date of expiry of the lease or license. Herein, to remove or transport from the quarry. As a matter of fact, I had already transported out of the quarry lease area, and no, it is admitted in the notice itself, Annexure A itself. They have categorically stated, my lords, it is at page number 28, Annexure A, my lords. In the first paragraph, bottom, my lords, the last sentence of the first paragraph, you have submitted a request letter cited at reference to dispose the ordinary stand stored in the stockyard. I am 1 kilometer away. Page number 28, my lords.
Page 28.
28. It's a typed copy.
Yes. So read it.
Yes, sir.
Period of lease was expired on 11/4/20. You have submitted request letter as discussed in the meeting.
And in the last paragraph also, it is made amply clear, the last sentence. Therefore, it is hereby informed that there is no provision to transport the sand from the lease area into bracket stockyard after the expiry of 6 months.
Where is it? You are transported where?
Because I am allotted a land in the river stream. After removing therefrom, I can't store there. I should necessarily take to a stockyard, which is designated, which is 1 kilometer away. That is permissible under rules, my lord. And there is a surveillance or solar fencing maintained by the department, my lords. It is stored in the stockyard. It is not in the quarry lease area. If the ordinary sand is stored in the lease area, quarry lease area, my lords, rule 6.4 would have attracted. If it is removed or transported out of the quarry lease area.
Out of the quarry lease area, where is that? Where is that words, out of the quarry lease area?
That word is, in explicit terms, it is not there. It is rule 6.4 very clearly says that extracted from a quarry during the lease area expiry lease license. The second sentence I may kindly be permitted to read. If the lessee or licensee fails to remove or transport the minor mineral extracted within the period of 6 months from the date of expiry of the lease or license, the minor mineral so extracted shall be the property of the state government and it shall be disposed as per chapter 8 of these rules. So the word extracted means extracted from the quarry.
What do you say?
My submission is not that this impugned order is passed by the senior geologist, which is a revisable order. The second aspect of the matter,
It is appealable
it is revisable
under
under
revised-
53,
revised- under
53 of Karnataka minor
of the minor mineral
concession rules. And so far as the contention of the petitioner that it is removed from the stockyard is incorrect, because in case of sand mining, the lease, quarry lease area includes the stockyard also, because the quarried sand cannot be stored in the river bed. Therefore, it will be stocked in the nearby within.
That is what they are saying.
Within, and for transportation of quarry sand from the river bed to the stockyard, they will not obtain MDP. MDP, mineral dispatch permit. Mineral dispatch permit will be obtained from the stockyard to the destination. Therefore, the contention of the other side that it is being transported, already transported to the stockyard, therefore this 6.4 is not applicable is incorrect. So 6.4 is clearly applicable because it is a quarry sand. And he has not removed it within 6 months from the date of expiry.
So they must take the mineral transport dispatch permit.
That is within 6 months. After 6 months,
It is not obtained, then the presumption is that it is lying in the custody of the.
Yes.
The mineral dispatch permit is not obtained.
Yes.
Within 6 months. Then according to perhaps your submission is that it will be presumed that they are not removed and the
yes,
material is lying in the custody of the.
Custody of the.
Because there are
And
two.
one more aspect.
You have obtained the mineral dispatch permit?
No, I have not. My contention, there are two words are found therein: remove or transport.
Whatever, that is the question of fact. You want to go for revision of remedy of revision, or you
So,
want?
if my lords, if it is the contention, I may be relegated for revision, my lords, but with one or two observations
In
in
course
this
of the,
And
what?
one more
observation,
submission.
because for the last so many years, the revision files are lying there. Second thing, and there is a third party rights are not created. And moreover, the interim orders are not usually granted to protect my interest.
So revisions
Sub-
are not proceeded with.
No, Lord, it is.
There is
taken
not
up
even
in
a
the-
single instance of all these. There are two revising orders, one in Bellary, one in Mysore. Not even a single interim order has been passed. Our rights are not protected because I have invested huge money there, or per metric ton 891 rupees is the extraction cost.
Patents are disposed of within what time normally?
No time limit. That's why in the last occasion it was more than 10 years, and in one case it is 17 years, my lords.
Page number 98 is the order passed by the District Sand Committee, Bellary, wherein Lord, 34,10,202 penalty has been imposed against the petitioner on 12/2/2024. this amount has not been paid and this order is not under charge.
This is one of the contentious issues, my lords. Because
What you are pointing out?
Lord, in page number 99, Lord, District Monitoring Committee has imposed 34 lakhs fine. He has not paid that, neither he has challenged this order. Now he is seeking transportation of the.
Nor challenge the order, nor.
that is challenged, my lords.
Where?
I have made a representation that is challenged, my lords. Now the issue
Let him
is,
show, Lord, it is not challenged, I am sorry.
Unfortunately, you have got the remedy of 53.
beg your pardon?
You have gone into all these aspects.
So because the 5 years period, 1 year during COVID period, I could not extract 50% minimum target, my lords. For that, that is a reason beyond my control. It is a natural calamity. It should have been in other cases, it has been reduced to nil penalty. Only in this case, because previously it was imposed at 1.55 crores. It is reduced to 34 crores, 34 lakhs arbitrarily. That itself is also a challenge. I have given the representation, which is at page number
So you were relegating you.
Yes,
Rule-
my lord.
Rule 53 of the.
Please, my
Right.
lords. Please, my lords. With these 2-3 observations, my lords.
Rule 53 of the Karnataka Minor Mineral Concession Rules 1994, occurring in chapter 9 under the title Revision and Miscellaneous, provides for remedy of revision in Rule 53 of the said rules. Sub-Rule 1 of Rule 53 provides that any person aggrieved by an order of competent authority, not above the rank of additional director, may, within the stipulated time of 90 days from the date of communication of the order, may prefer the appeal. Paragraph. The aforesaid statutory remedy of revision is available to the petitioner in respect of the order dated 22nd March 2024, passed by the senior geologist, Mines and Geology Department, whereby the petitioner is not permitted to transport the mineral sand from the lease area in view of the expiry of 6 months, from the date of expiry of the lease. Full stop. Learned Advocate Mr. Polle. This is serial number 7. Ravindra Gajanan Polle could not dispute the aforesaid legal position emanating from Rule 53 of the aforesaid rules that the remedy in form of revision is available. When remedy is available in law, this court is not inclined to exercise its extraordinary writ jurisdiction under Article 226 of the Constitution. It is open to the petitioner to avail the aforesaid remedy of revision to contest his case in the grievance. Paragraph. This court does not express any opinion on the merits of the case of the petitioner. The petitioner is relegated to the remedy of revision accordingly. Post of the petition is disposed.
Third party protection, my lords.
State learned advocate for the petitioner submitted that authority may be directed to dispose of the revision at the earliest. Post of it.
And also
Observed
the
in this
time
regard
limit, my lords.
that the revision authority shall proceed with the revision if filed expeditiously so as to decide the same, preferably within a period of 3 months.
Because there are pendency of revision.
They are preferable, subject to the pendency of the other.
Yes.
So, but
Subject to
in
the
the
pendency.
meantime, my interim protection may, they may
I
be direct.
oppose
I'm
your
not
any-
asking at my lords, at here, my lords. They may consider my interim application, my lord, in accordance with law.
It goes without saying that if the interim application is filed before the reviewing authority, same shall be considered by the authority in accordance with law and on its own merits.
Please, my lord.
That petition is disposed of and the process comes.
Number 8, Ashok B. Mulade.
My lord, I am appearing for the petitioner.
Copy is not served on him. Copy of the petition is not served.
He says that some hazardous stocks are lying at his premises. In that view, he may be permitted to run the plant and clear the stock by utilizing. Otherwise, it may result into some accident. So what is hazardous, we do not know. We issue notice. We will issue notice.
Let him furnish a copy, my lord, copy is not served.
You give copy to the council, government council, Mr. What is your good name? Mr. Petitioner.
My lord, may I-
Apply copy to the learned council for the state government.
please. My
When
lord,
you will
sir.
supply? When you will supply? Learned advocate for the petitioner, Mr. So and so, stated that he will supply within 2 days copy of the present petition to learned government advocate, Mr. Mahindra, who shall on the next date take instructions and assist the court. Stand over to Monday. Monday is 24th. 24th.
My lord, may I supply?
If you are in hurry, then today supply copy. He wants some hazardous stocks to be.
Yes, they have given 7 days time, my lord, but that is expired. 7 days time they have given, but that
No,
is
sir.
expired.
7 days time, if you give, your factor will blast.
Yes, no, sir, I am stating that they have given me 7 days time. Within that, they have seized the premises. There is a possibility of blast. That is apprehension I am also having, my lords.
You give copy, Mr. Counsel, to the.
My lords, I have served in the Kalburgi bench, but that is not forwarded. I will.
9 urgent, seal number 10, Mr. Rai Appa Vayadari.
Hearing for the first response.
15 days delay. What is it about?
Pray for a short accommodation, my lord. 2 days time maybe.
2 days time for what?
My lord, this is against an interim order, my lord, where a direction has been issued to pay compound interest on the gratuity amount that has to be paid by the appellant to its ex-employee.
Why do you want time?
Well, I need to take out some judgment, Supreme Court judgment, my lord. There are Supreme Court judgments fixing the interest at 10%, my lord. In this case, we already paid the gratuity amount and 10%.
This is interim order. You
My lord, it is.
fight out your case in the.
My lord, it's not an interim. I order
This
passed
is
on
a-
IA.
this
Yes,
is
my
an
lord, order
interim
passed on IA. In a disposed of matter, this honorable court in contempt petition has directed the parties to. Lord, may I read the.
God,
contempt-
learned advocate,
My lord,
Mr.
my lord, my lord,
What is your good name?
my lord, my lord,
What is your good name?
Rayappa.
This is serial number 10. 10?
10.
You are Rayappa Hadagali.
Yes, my lord.
Learned Rayappa by Hadagali for the petitioner. Appellant.
My lord, may I produce some judgments are there, my lord.
Judgment,
Ask this
we
honorable
don't
court.
go to judgment because in law, give us. It is interim order.
My lord, interim order, my lord, it
In
is
IA,
passed in the- yes, my lord.
some amount is permitted to be withdrawn
The disposal of the matter.
toward gratuity,
Yes, my lord.
subject to outcome of the petition. What is more required?
Appellant is a Sikh company, my lord. Appellant is a Sikh company.
What is
And-
this long, this compilation for interim? What is this?
My lord, annexure B, my lord, may I kindly see, my lord, annexure B, my lord. Annexure B, my lord.
Annexure?
Annexure B, my lord.
B.
Before that, my lord, annexure R1, my lord. Annexure R1 at page 84. Accept me, my lord, as per the order passed by the respondent number 3, Assistant Labor Commissioner, the appellant is liable to pay gratuity amount with simple interest from the date of the due, my lord, till
Now
the
this
date of
respond number
payment.
3 to 34 are the employees.
Yes, my lord, 31 employees.
So we'll say that payment of amount.
We
will
already
come-
paid, we already paid the gratuity.
We'll say that the payment of amount already paid under this order will remain subject to outcome of the petition. Even
The
otherwise,
petition is not pending, my lord, petition is disposed of.
it is disposed of.
Disposed of, my lord, that's right. In the, my lord, may I read the contempt order, my lord? In the, my lord told, my lord, as per my, this thing, my lord, I have paid the excess amount.
Our learned advocate, Mr. So-and-so, notice returnable on 20th July. 20th is holiday. 22nd July. Yes, next.
Number 11, Nagaraj.
Number 11 and 12 minutes. My request for the passover minutes.
Passover.
Senior
Passover will not be possible. Why?
The senior counsel is engaged.
My lords, they have filed an application with certain documents, my lords. I'll take instructions on those. I request it may be taken up next week, my lords. Matter pertains to elections of the Kolar Milk Union, the Tumkur Milk Union, where we have given the schedule of dates for which they have filed certain documents.
This is that election.
Please, Cooperative Society.
So what remains now? They are,
Not single judge directed. to
now they have announced the election program.
There's a schedule is
Election
been.
program is underway.
Not
It has
this-
progressed to a large extent.
Not this is.
Almost half of the stages are exhausted. What is the stage? They give the program.
Let's say filed a
But
memo, my
You
lords.
go on
on 20
prolonging
Not, it's not a question of prolonging.
and then you blast
Not-
against the court. That
not
court
slight-
is not disposing.
slight difference in this case argued was senior counsel argued. Administrator, my lord, is
There is a-
appointed.
My lords, memo dated 28/5/24, my lords. The schedule is at annexure R1, page 2.
Memo dated
28th of May, my lords. 28/5/24, it was filed in open court.
28/5 years.
Please. ma'am. Annexure R1, my lords, page 2 is the schedule.
Not previous dates. Not
So list of voter is under preparation.
Please.
Not, that is not the point. Not previous dates when lordship heard the
See
matter.
the point. We have not heard. We have said that we are going to
Please.
dispose of the matter.
Please, not, it was, not be convinced before lordship, not that administrator
You
was
can't go on
appointed.
prolonging the matter like that.
Not issue is not, the administrator is not.
What can be done now? What do you want now? You want election to be held tomorrow without list
Not
of
single
voters?
judge direction.
Without
was-
list of voters, without objections, without finalization.
Not
You-
calendar of event was issued. They
This
start
is
the
all-
election process.
These are all statutory stages, Mr.
Not now,
Counsel.
once again, they have to redo the process. They want to redo the process. Not now election, they want to conduct in the month of October. Term
Oh,
lordship
they have
was expected.
started. They started in the month of May. Where is the question of October? They have started the process in the month of May.
No, this is pursuant to lordship direction. When lordship directed them, administrator cannot extend behind
That
6
is
months.
over. Everything is over. Now they have announced the election program.
Notes, may I
Which is-
request only one password note because senior counsel argued much and he convinced his court notes.
So then why you are arguing?
Notes. I request only for a password notes.
It is also a way of prolonging.
No, my lords.
Once the senior argues, then junior argues,
Notes,
again junior argues.
I didn't want to argue notes. I just only notes brought notice to this court notes. Several dates notes lordship was convinced because administrator cannot continue beyond 6 months and the election should be held. Notes, the single judge order was also the election should be conducted by month of July.
And don't take court for granted. You have been witnessing in this matter. When do you want?
Next week notes.
When do you want? When the petition was called out, learned advocate Mr.
Sarvanais. Sarvanais.
Sarvanaya wanted adjournment. As per the requests, stand over to
Day after tomorrow.
day after tomorrow, 21st.
Number 12.
Yes, there is
Well-
one impleading application filed, my lord. I have to file objection to that, my lord, impleading application.
What is it?
Already been filled up.
May I, my lord?
Yesterday, my
The elections are also concluded, my lords.
There are subsequent events, my lord, which I have to brought to your lordship's notice by way of an application. My lord, the petitioner, my lord, the appellant herein was elected, my lord, to the primary society, of a primary cooperative society on, my lord, 28/10/2018 for a period of 5 years. My lord, from the primary society, my lord, he has elected to the secondary society as a representative of a primary society on 8/9/2019, and his term is going to expire, my lord, on 7/9/2024. Meanwhile, my lord, what has happened is in the primary society, my lord, my elections was not conducted before expiry. Therefore, my lord, the society, secondary society where I have been elected, they have issued an endorsement. My lord, the secondary society, my lord, has issued an endorsement saying, my lord, my directorship to the primary society has been ceased. Therefore, you no longer will be continued as a secondary society director. My lord, that was came to be challenged before a single judge. Single judge, my lord, has dismissed. Now, my lord, I am before your lordships. When will, my lord, the subsequent events is now primary society, my lord, where I have been seized as a director, his election was conducted and I have been re-elected, my lord.
Where is annexure D in the main petition?
Yes, my lord.
Page.
My lord, page 60, my lord, 60 in page. And the translation copy is at 61.
So your appointment was coterminous with the
Yes, my lord.
tenure of
Because,
the
my lord,
body.
they have not conducted election to the primary
Now
society
let
on
us see.
time.
We'll consider. What is your grievance now?
Yes, my lord. My lord, now the
Wanted-
subsequent events, my lord,
You-
during the pendency of this
One
appeal.
sec- One
Yes.
second, one by one. You wanted annexure D to set
First,
aside.
set aside.
Now what learned single judge did?
Well, single judge, my lord, we have interpreted 18B, my lord, saying that 18(1)B was not applicable.
Yes.
Single judge said it is applicable because since I have no election was conducted, I have ceased as a director of the primary society. Now that the election is conducted, my lord, during the pendency of this writ appeal, so therefore, my lord, I come as a, my lord, again become a director of the secondary society. My lord, now the scenario has changed because I have been re-elected again to the primary society.
Who?
I have been re-elected, my lord.
Then where is the question? He is re-elected?
Yes.
He is re-elected for the primary society, my lords. His vacancy has already been filled by co-opting. His vacancy no longer exists in view of his cessation of the directorship.
Now your term was over once the administrator was appointed. It was coterminous with the original term. Now fresh
No,
election.
it is not coterminous.
Let us see the provisions.
Please, Your Lordships.
28A5.
My lord, your lordships may kindly see the facts, my lord, before that. My lord, the petitioner, the appellant, my lord, was elected to the primary society. That is, my lord, respondent number 3. Respondent number 3 on 28/10/2018. The primary society, my lord, have been elected on 28/10/2018 for a period of 5 years, my lord. That will come to an end on 27/10/2023. Correct. In respect of respondent number 3. From there, my lord, I have been sent to secondary society, that is respondent number 4. My lord, there, my lord, I have conducted the election on behalf of petitioner. I have been sent as a delegate of the petitioner number 3 society to represent in the election of respondent number 4 society. That election was conducted on 18/9/2019. 8/9/2019. And that will expire, my lord, on 7/9/2024. Even there, my lord, I have get 5 years term.
This is what? Secondary.
Secondary society.
Secondary society.
That is the respondent number 4 society.
So you were initially elected to primary society in 18.
Yes, my lord.
Then your term was to last till 23.
23.
During that term, you got elected in secondary.
Secondary society.
Where your term is to last on till 7/9/24.
Correct, my lord.
Now what is it? What is the
Now what happened, my lord, in the primary society elections, my lord, were supposed to be conducted before 7/10/2023.
Right.
27/10/2023.
27/10.
27/10/2023. That was not conducted, my lord, for the various reasons. Therefore, my lord, an administrator came to be appointed to the primary society.
Your election to the secondary society was by virtue of your position.
Yes, yes, my lord.
That's
Yes,
the point.
yes, correct, my lord. Now, in the meantime, my lord, they have issued an endorsement saying 18B says, my lord, if I have ceases to be a director of the primary society, I get ceases to be a director of the secondary society.
Naturally.
Now, what has happened, my lord? If suppose, my lord, the election was conducted before expiry, if I were to get re-elected, this question wouldn't have arisen. This scenario was arised, my lord, because of non-conduct of election before expiry of my term. Now, administrator was appointed. Meantime, they have issued an endorsement, my lord. Writ petition was during the pendency of this writ appeal, my lord. Now the election was conducted to the primary society. Again, I have re-elected. So my secondary society, my lord, term still survives because I have been elected for a period of 5 years. That is what, my lord, 28A5 says. Because
in logic, it is excellent, but in law, it is hopeless.
New cause of action. But I
Your logic is excellent, but in law, it is hopeless.
My lord, if the elections
Can't
were to
happen.
my lord, if the elections
Gone
were
is gone.
my lord, if
Your
the
term is over, your term was coterminous. You
my lord, it
can't
is not coterminous. That
revive
is
it
what,
because press election is held.
my lord, if were to be a coterminous, my lord, I had no case, my lord. It is not coterminous.
Even otherwise, the term was over. Press elections are held. Now you can't revive the old things for you to seek a
My lord,
seat.
if I were not elected, re-elected, my lord, then I had no case, my lord. Because I have re-elected. If the elections were conducted before expiry, my lord, this scenario wouldn't have arisen. The elections was not conducted by the election authority. For that, my lord, I shouldn't be suffered.
He has already been filled up.
My lord, that is
Counter is filed.
Counter is filed in the writ petition, my lords. Writ appeal we have not.
Writ appeal it is.
It's not.
Appeal we have not.
now the co-option, my lord, is
We don't
done.
have the counter. Counter copy nahi. Once.
Application not seeking implement what is pending.
It is there. It must be.
Nominated by the Minister of Law.
It must be there. It is there. Yes. Statement. of it. So today you are for the post of director.
Director, my lord.
That is-
Okay, your lordship may kindly see 18B for a moment. my lord.
So your directorship goes by virtue of your membership in the primary society.
Primary society.
So their election were not held.
Election was not held, my lord. Therefore, my lord, secondary society issued an endorsement saying that your primary society election was not conducted. You are seized. Now the elections are conducted, I have re-elected, my lord, because the term in the secondary society is also for a period of 5 years. I have guaranteed, my lord, by the act, my lord, for a period of 5 years. Your lordships may kindly see 28A4. There is no provision, my lord, which says that it is a coterminous. My primary society term is, if it is, my lord, my primary term and the secondary term is coterminous, my lord, I had no case. My lord, the secondary society, I have got elected. I have got elected, my lord.
His logic is wonderful.
My lord,
Will not accept it. Not in law, it is not acceptable.
Well, 28A, your lordships may kindly see, my lord. 28A4. 28A4, my lord. My lord, subject to the provisions of section 29A and 39A, the term of office of the members of the board shall save as otherwise 5 years from the date of election, and they shall be deemed to have vacated office as the members of the board on the date of completion of the said term. My lord, the term, my lord, to the secondary society is still there. I have been, my lord, for qualification, I have been secondary society election, my lord. Primary society has sent me as a delegate. I have got a qualification, my lord, to conduct an election to the secondary society. I have conducted an election, my lord, on
which provision? 28?
28A. 28A subclause 4.
28.8.
28A4.
28A4.
Yes.
Subject to the provisions of
29A and 39A, the term of the members of the boards shall save as otherwise 5 years from the date of election, and they shall be deemed to have vacated office as such members of the board on the date of completion of the said term.
So this is related to your secondary.
Yes, my lord. Your lordship rightly pointed out, my lord, if it is to be a coterminous, my lord, I had no case because the primary society term is over, secondary I have to vacate. It is not the case
Your
here.
membership in the secondary society was by virtue of the primary.
Yes.
Correct, my lord. That is.
That the route goes that.
No, my lord, for that member,
Like, my lord,
18B, my lords.
my lordship may kindly see 18B.
18B, my lords.
18B, your lordship may kindly see.
18B.
18B.
18 capital B.
This is where, my lord, I have been issued an endorsement under section 18B.
Ceases to be a director.
A
of the
director
primary-
of a secondary cooperative society or a federal society or an apex society.
You are director of secondary society.
Yes. Or an apex society who is a representative of another cooperative society shall ceases to be a director of such cooperative society forthwith if he ceases to be a director of the primary or secondary cooperative society which he represents.
That is what
In
is
case of
invoked.
amalgamation
That is invoked.
reorganization.
Simple. This answers.
Correct, my lord. I have not, now at present, my lord, I have not ceases to be a member of the director of the primary society because I have re-elected. Let us look at the
The
scenario, my lord.
subsequent event, my lords, he'll not get the same benefit for that date.
My lord, then 18A5 will become a district, my lord. 18A4, I have been guaranteed 5 years term. If the, my lord, if the elections were conducted before, my lord, expiry of the primary society, this scenario wouldn't have arisen. It is not my lord, it is an election authority who has to conduct an election. For their fault, my lord, I should not be punished. And there is no provision, my lord, in the act which says that my primary term is coterminous with a secondary term. My lord, my 5 years term has to be.
Lord, it is like if a speaker is elected and if his term is.
Exactly, that is passing in my mind.
He cannot come back again as a speaker.
Exactly. Exactly, that is exactly my passing in my mind. A speaker of Lok Sabha, who is a speaker by virtue of membership of the Lok Sabha, gets re-elected in the second election after 5 years as a member of parliament. Then can he say that I am also a speaker now? Exactly is passing in my mind, Mr. Counsel.
Otherwise,
that is wonderful.
My lord, 18B, my lord. Got that scenario, my lord, has. My lord, if my only question is this, my lord, if I were to be elected again before my expiry of the primary society.
You are relying on which provisions?
My lord, 28A4.
28A4.
A4.
Of which Karnataka
Cooperative Societies Act 1959.
It is section.
Section 28A4, my lord.
28A4.
This is 18B.
Please.
18B1 is, my lord, which they have relied.
Let us see what learner single judge said.
Yes. My lord, in learner single judge, my lord, we were, my lord, argued saying that 18B was not at all applicable because there is a continuation, an amendment was taken place.
Sorry.
At that time, my lord, the scenario was different. My lord, now, since I have re-elected, my lord, therefore,
Section
I have re-elected, my
29E
lord.
also, my lords may consider.
I have got re-elected on
Top
19/5.
My lord, section
And
29E,
my
my
brother
lords.
is rightly saying that your membership in the secondary society is filled in.
Yes, under section 29E, my lords.
29.
E, my lords.
29E, my lord, that is, my lord, during the interim, my lord, till the conduct of election, they can nominate it. The vote, the register has nominated in my place.
Nomination was done in pursuance with the order passed by the minutes.
Section 29, capital E, my lords.
The election.
Please.
Well, the judgment relied by the learned single judge division bench. 18B, man. ಇದಾ?
That's one clarification. 29E is nomination, my lords. 29E is nomination by the government for the vacancy.
By co-op.
Please.
It has been co-opted, my lord, till the election is conducted because there was a vacancy.
So your doors are closed. By virtue of the developments. Dismissed.
Great.
You will get order after 2-3 days. Completing. Completing, not due to.
13 urgent, syllabus 14. Anish Acharya.
That appear for the Appellant's Council. That the appellant filed a petition under section 95 of the Insolvency and Bankruptcy Code. Now, it was against the personal guarantors of a corporate debtor, which consist of the partnership concerned, also all the partners. Now, what is challenged in the writ petition? Well, I'll draw your lordship's attention to page number 48 at page number 62. This is the writ petition filed by the respondent number 1 before your lordship. Page number 62, may draw your lordship's kind attention to, my lord. It was registered before the NCLT. Now, page 62, my lord, memorandum of writ petition. Your lordship got it, my lord? Blood. What was challenged before the learned single judge, as can be found at page number 77, para 23, is page number 77, para 23. This is the entire gamut of the writ petition.
Page 77.
Page 77, para 23, Mala, of the writ petition. Para 23, yes, ma'am. Being wholly aggrieved by the administrative act of the first respondent, that is the NCLT, in
Yes,
receiving
Mr.
the
What is-
petition.
What kind of petition you filed?
They had
who is the
filed.
petition?
They wanted the learned judge, single judge, to take over the job of the resolution.
What is your contention in substance?
There is no notification.
No jurisdiction.
No jurisdiction. Yes.
So take it before the NCLT.
Difficulty.
Not again the filing of the petition.
Lack of jurisdiction is an issue.
Lack of jurisdiction can't be agitated at time of lodging the petition.
But can I say only 2 points? Only 2 submissions.
Let us see what is this rule 95.
Please see rule 9,
No, you
section
may be-
95 as well as 96.
You may be right,
All-
but let us see.
Well,
prima
it's
facie
all
doesn't appear.
time-bound manner under section 97,
You may
3.
be right that, but what is 97?
Yes.
95. Application by creditor. But then who will decide this about the jurisdiction?
What happens is this, once a petition is filed under section 97(3) of the Act, the NCLT should direct the board to nominate the resolution professional within a period of 7 days. It's all time-bound. Thereafter, under section 97(4), the board shall nominate the resolution professional within a period of 10 days.
What are the subject matter?
That subject matter is this. Milord, I am the developer, they are the landowners. It consists of the company and the partnership and also all the partners. A sum of which,
Your partners.
yes, no, they are the partnership concerned, also the partners, individual liable. No, there was an agreement under which, Milord, we paid about 183 crores to them. Then they subsequently, there was a loan agreement which said out of 183 crores, 40 crores will be converted into loan payable by the company and the partners together jointly. It's a joint agreement. Then they defaulted in payment of the amount. So we invoked section 95 because the partners stood as guarantee. Your lordships are aware under section 126 of the Contract Act, even the guarantee can be oral. Now we invoked section 95. They said they are not liable. So we filed section 95 petition. They said the very registration is challenged before the NCLT. The learned single judge, it is all time bound. Within 7 days, the NCLT should direct the board to nominate the RP. The RP will be nominated within 10 days. Then the RP will submit the report within 10 days, the 14 days thereafter, and the NCLT will decide whether to accept the recommendation or not. It's within 41 days. It can be reduced also because the RP can submit the report within 2 days.
That is under which provision?
Pardon me?
That is under which provision?
97.
97. May drive lordships at attention.
97(3).
Yes,
This
section.
law is very detailedly explained in Jivraj's judgment. My lord, this is only overlooked by my lord.
Pass over
May I
that
just- may I
judgment.
just- madam? Kindly, my lord, have Jivraj's judgment. My lord, I will only take your lordship, my lord, 2 areas. Kindly, my lord, have page number 51. My lord, paragraph 51 and page number 43. Paragraph 51, my lord, page number 43. The duties of the resolution professional in a process under chapter 3 and part 3 are contained in section 99. The resolution professional is required firstly to examine the application within 10 days of the appointment. Secondly, they may require the debtor to prove that the repayment of the debt which is claimed to be unpaid by the creditor has taken place.
1 second. Where you are reading?
I am reading on my lord, internal page number 43, paragraph 51. Lord, may I just read it, my lord, again? The duties of the resolution professional in a process under chapter 3 of part 3 are contained in section 99. The resolution professional is required firstly to examine the application within 10 days of the appointment. Secondly, they may require the debtor to prove the repayment of the debt which is claimed to be unpaid by the creditor has taken place. The debtor may also so by evidencing an electronic transfer of the unpaid amount from a bank account of the debtor or produce evidence of the encashment of the check issued by the debtor or signed acknowledgement, etc. My lords, may kindly now come to paragraph 53. 53. Yes. The resolution professional is required to examine the application and to
95.
ascertain 2 things. Firstly, application satisfies the requirement of section 94 or section 95. And secondly, the applicant has provided the information and furnished the explanation which is sought under subsection 4. Having carried out the process of examination and ascertainment as specified in subsection 6, the resolution professional may either recommend the acceptance or rejection of the application by submitting a report. The report has to record the reasons and a copy of the report has to be furnished by the debtor to the creditor as the case may be. The role of the resolution professional prior to the adjudication process by the adjudicating authority comes to a conclusion.
Correct.
Yes,
So
sir.
mere filing of petition under 95 does not commence the adjudicatory process.
No.
No, my lord, no.
That
Their
is-
only grievance was, their only grievance was when a petition is filed under section 95, the moratorium kicks in.
Even 97(3) doesn't commence the process.
No, no, no.
My lords, may kindly for a moment read, my lord, may I request your lordship to, my lord, allow me to read paragraph 54, my lord, this clarifies even further, very important. The salient aspect which emerges from the above analysis is that the resolution professional does not possess the adjudicatory
Correct.
function in terms of the provisions of section 99.
True.
In chapter 3.
This
is what it
function
is.
they want the learned single judge to handle.
The only thing what happens, my lord, under section 95 petition, the moment the petition is filed, a moratorium kicks in. My lord, the moratorium
That's
kicks
only
in, my
for-
lord, which is an automatic
only for
moratorium, my
limited
lord,
period.
under section
So
7.
moratorium starts when the petition is
Moment the petition is filed,
95.
95 petition. My lord, that will be there for a period of
But
10 days.
then they may be arguing that it will mark the assumption of jurisdiction by NCLT.
Yes, my lord.
If the jurisdiction was not available, then why at 95 stage itself should be accepted?
Exactly, my lord. Now, my lord,
That is
this
what they
very
are saying.
question- This very question was, my lord, the question before the Honorable Supreme Court in Jivraj Ka, my lord, in Jivraj Ka.
This is Jivraj.
My lord, my lord, the basis for Jivraj Ka's case, which your lordship should kindly find on page number, my lord, 26.
So they want to take advantage of the moratorium.
My lord, their case was that moratorium, which will be there for a period of 10 days, is being taken advantage by us. Therefore, the NCLT, the High Court should step in. My lord, if that is a period of only 10 days, my lord, within 10 days, the process is so fair that even they are called upon. My lord, this very fact, my lord, this very component of, my lord, the section 95 was a challenge before Jivraj Ka in Supreme Court. The argument was that section 95 is blindfold. It takes away the opportunity, kicks in the moratorium without hearing the parties. Therefore, that itself is illegal. My lord, this was the basis. Kindly, my lord, have page number 26, my lord, for a moment of Jivraj Ka's, my lord, the basis, paragraph 25, my lord.
There,
But there were a batch of petitions, my lord, all across the country, my lord, challenging this very provision as, my lord, unfair. Page number 50, page number 26, my lord, paragraph 25. Primary, in the bottom of page number 26.
We are not concluding anything.
Yes.
Because at least I am concerned, I am not that much well versed with this NCLT and law. So we'll like to hear.
Yes.
Yes.
No, my lord, paragraph, my lord, 25 on page number 26. Kindly, my lord, see the question that was before the Honorable Supreme Court in
But
deciding this batch of matters.
Paragraph 25 you are reading?
Yes, my lord, I am reading paragraph 25, my lord, on page number 26. Primarily, the submission which has been urged on behalf of the petitioners by so-and-so postulates that the fundamental aspect as to whether the jurisdiction to entertain an application under Chapter 3 of Part 3 exists must be determined at the threshold by giving the debtor or a personal guarantor an opportunity to be heard. The submission is that logically the determination of the jurisdictional question has to take place first before the appointment of the resolution professional under section 97 clause 5. Consequently, it has been submitted that the adjudicating authority must be required to determine at the threshold whether A, debt exceeds, B, whether the debt has been affected. My lord, this was because
This was the submission.
this was, my lord, the basis for Jivraj case. My lord, what happens, my lord, under the IBC, there are three provisions, my lord, majorly. One, my lord, section 7, which is, my lord,
Corporate debtor.
speaking of corporate debtor, my lord, insolvency. Section 9 and section 95. In respect of section 7 and 9 applications, my lord, the moratorium comes in after the admission. After the admission, an order of admission passed by the NCLT after issuing notice.
Correct.
But, my lord, unlike section 7 and 9, in respect of 95, the language, my lord, may
So
just read
what is the difference between section 7,
Section
9
7
and 95?
Yes, my lord. I'll let
That's 7 is against the corporate debtor.
7 is against the
Corporate
debtor.
debt. And this is individual.
7 is financial credit.
Individual.
Yes, 7, my lord, 7 is financial credit. 9 is, my lord, operational credit. 95, my lord, is against, my lord,
Personal
the
guarantee.
personal guarantors of the corporate debtor. And, my lord, what would happen is, my lord, once section 7 or 9 is filed,
Yes.
moratorium comes in, my lord, after the order of admission passed by the NCLT. Unlike, my lord, section 7 and 9, in respect of 95 petition, by virtue of 96, my lord, the moment it is filed, I just, my lord, read the language of, my lord, section 96 for a moment, my lord, 96 of IBC.
Interim moratorium.
Interim moratorium. When an application is filed under section 94 or 95, my lord, this is what happens. Now, my lord, even this was, my lord, a matter of interpretation before several courts. My lord, the court said that filing, even presentation of the application or through e-filing itself is sufficient for, my lord, filing. My lord, therefore, the grievance was that, my lord, in the batch of writ petition, that unlike 7 and 9, which gives an opportunity and then the adjudicating authority decides, section 95 would kick in an automatic moratorium. Wherefore, there is going to be miscarriage of justice. This was what, my lord, the subject matter. Honorable Supreme Court, my lord, in Jivrajka's case held that it is constitutional, it is automatic. For two reasons, my lord.
Now, this argument in paragraph 25
Yes.
of the council was rejected.
Was rejected. Then, my lord, what would happen? The moratorium that kicks in, my lord, by presentation of section 95 petition is not, my lord, for times immemorial. It is only for 10 days within which the resolution professional, my lord, has to, my lord, give his findings.
Report.
Yes, to the adjudicating authority. And, my lord, the resolution professional would do that.
So the process of adjudication starts when? At what stage? Section 102?
Yes, 102.
102.
Yes, 102.
Public notice.
Yes.
Of the claims.
Yes.
So that is that marks the commencement of the adjudicating process.
Yes.
Not 95 filing.
No.
That is your case.
Now, my lord, what happened?
Therefore,
Because
the question of jurisdiction cannot be examined at the stage of 95, but at the stage of 102 and the subsequent proceeding.
it should be led to the discretion of the RP and to the adjudicating authority. My lord, that jurisdiction of, my lord, it is mere scrutiny.
Why RP?
My lord, it is first the
Report.
resolutional professional, my lord, would go through the application. He would raise a report. Even after, my lord, hearing
No,
the other side.
RP can examine the question of jurisdiction.
Not, my lord. He only passes a report.
Report.
He only passes a report. And the adjudicating authority, my lord, all these are on time bound, my lord, scale. Once, my lord, that happens, the adjudicating authority tomorrow, if
Now, this NCLT law is adopted from somewhere, some guidelines are from foreign law, or how it is?
IBC itself, my lord, is a borrowed legislation, my lord.
Borrowed where? From where?
Borrowed, my lord, across various, my lord, countries of the globe.
Well, there was an act called Lordship, the Sikh
appears.
Industrial Undertakings Act was there that provided for rejuvenation of the company.
Yes, now we have understood your case in a reverse project. Now we'll.
Now, my lords, may kindly also see, my lord, before, my lord, I part 101, my lord, the moratorium, when an application is admitted under section 100, a moratorium shall commence in relation to all the debts and shall cease to have effect at the end of the period of 180 days beginning with the date of admission of the application and on the date adjudicating authority passes an order on the repayment plan, so whatsoever. During the moratorium period, my lord, the proceedings are stayed. Now, my lord, what happened, my lord, factually, my lord, a small factual background. The moment, my lord, when this 95 petition was filed, there was an arbitration, my lord, that was going on between the parties. Moment this petition was filed, my lord, in the arbitration proceedings also there were admissions with regard to this liability, and my lord, the arbitration proceedings were on. The moment this petition was filed, we filed a memo before the arbitral tribunal. By rule of law, there is a moratorium. Please stop this proceeding till the NCLT decides the matter. My lord, soon that memo was filed. The arbitral tribunal took the matter for consideration. Should we allow this memo or not? Before, my lord, the arbitral tribunal, my lord, was to decide that contention. They came before, my lord, this honorable court in a writ petition, said that no, the acceptance of the petition itself by the NCLT filing itself should be intervened. My lord, such an order was passed, and that order was not intimated to the arbitral tribunal. They let the arbitral tribunal also pass an order on this very memorial. No, my lord, what is happening is, on one scale, my lord, the arbitrators are deciding the fate of the section 95 petition. Secondly, my lord, the learned single judge, my lord, decides to the extent that even the filing can be interfered by this honorable court, my lord, in writ jurisdiction, my lord, which is virtually taking over, my lord, the functionalities of, my lord, the RP and the NCLT, my lord, which is not the scheme of act, my lord. If that is accepted, then, my lord, everyone who suffers, who gets an intimation of a section 95 having been filed, my lord, would, my lord, tumble into this honorable court. Kindly see, my lord, now this honorable court would be working, my lord, virtually, my lord, my lord, I apologize for this statement, my lord, virtually, my lord, the scrutiny functions would be, my lord, made to be done by this honorable court, my lord. In every petitioner, my lord, would come with that kind of a, my lord, prayer. And the law declared by the honorable Supreme Court in Jivrajka's case, my lord, is totally subdued. And, my lord, the miscarriage of justice, my lord, on the count of miscarriage of justice. Would it cause any miscarriage of justice? Absolutely not. What is, my lord, stopped is only the legal proceedings till the moratorium is decided. That's it.
Now this moratorium was, you said that 10 days.
The moratorium, my lord, kicks in within 10 days, my lord, the RP has to, my lord, do his job.
Then 101 says 180 days.
That, my lord, on an order of admission.
Upon order of it.
Yes, if NCLT, my lord, admits it, then, my lord, moratorium continues.
Till the disbursement.
Yes. If NCLT, my lord, dismisses my petition for whatsoever the reasons, my lord, I don't have a case, the petition itself could not have been filed on any of those counts. Petition is illegal, it is not notified whatsoever the counts, then, my lord, I go out of the tribunal.
Yes.
Lord, admitted position is that as between the appellant and the first respondent, there is an arbitration which is going on.
One second. Yes.
As between the appellant and first respondent, an arbitration is going on. But there had been multiple attempts by the appellant to stall this arbitration by various means.
Yes.
There were about 14 interim applications, 7 writ petitions as against the arbitration proceedings. One such attempt was a claim that there is a 95 petition filed under IBC. Therefore, in terms of section 96, you have to stay the arbitration.
This is rule or section?
What?
95 is section.
95 is section 95 IBC and claimed moratorium under section 96. And they said arbitration should be stayed. But at the first instance, your lordship will only have a look at that memo, which is at page 675. Page 676, not a 2-page memo, I'll find it. Page 703, madam, sir. Page 703. This is the memo filed by the appellant before your lordship, who is the respondent in the arbitration proceedings. May I read this, ma'am?
Yes.
The advocate for respondent most respectfully submits that we have received email on 23 November that the respondent have filed a company petition under section 95 insolvency and bankruptcy code before the Honorable National Company Law Tribunal. And in view of the said filing, we have been informed that an interim moratorium under section 96 of IBC has come into operation. The email dated 23rd November is annexed along with this memo and also a copy of the receipt for filing the application before the NCLT.
Yes.
The section 96 is reproduced here and below, not having reproduced over the page. It is submitted that in accordance with the above portion, any legal action or proceedings pending in respect of any debt shall be deemed to have been stayed. The Honorable Supreme Court of India, in the judgment of P. Mohan Raj and others, so-and-so has held proceedings in IBC includes proceeding before any court of law, tribunal, arbitration panel, or other authority. Further, Honorable Supreme Court in the judgment of Alchemist Asset Reconstruction has held as follows. Not having said all those things, please come to the next page, last paragraph. In the light of the above mentioned judgments and various other judgments, and in view of the interim moratorium coming into force under section 96 of IBC, it is most respectfully submitted that any legal proceedings, including the arbitral proceedings having both claim and counterclaim, is deemed to be stayed. Therefore, it is most respectfully paid that this tribunal may be pleased to suspend, adjourn the matter sine die in respect of justice. They did not rest with it. What they did is they sent communication in respect of all these individual partners to various banks and every place saying that there is a moratorium. So effectively, not stalling all their activities in respect of the individuals. Now, with these backgrounds, not only two submissions, Insolvency and Bankruptcy Code not seeks to address the insolvency situation of companies, individuals, and partnership firms. Part 2 speaks about companies which they call as corporate debtor. Part 2, my lord, is insolvency resolution for.
Please repeat your submission.
Yes, Mr. Insolvency and Bankruptcy Code seeks to address insolvency situations of companies, individuals, and partnership firms as a composite enactment.
Here.
Part 2 of the code, my lord, part 2 of the code is for insolvency resolution of corporate persons. This is starting from section 4 to section 77 capital A. Section 60 of this part 2 provides that the adjudicating authority in respect of these corporate persons would be the NCLT. Would be NCLT, National Company Law Tribunal. So jurisdiction in terms of part 2 is with NCLT. Now part 2 has been fully notified that it is in force in all sense. Petitions are being filed against companies. NCLT is exercising jurisdiction, adjudicating the matters. Now part 3, which is in respect of individuals and partnership firms. That starts from section 78 to 187. But 179, section 179 states that the adjudicating authority insofar as part 3 for individuals and partnership firms is DRT, Debts Recovery Tribunal.
Let us.
Yes. Can I at the first instance point out 179, lords? Or your lordship will prefer to see 60 at the first instance? $179, lord, insofar as individuals and partnership firms. adjudicating authority for individuals and partnership firms, subject to the provisions of 60.
Why it is subject to 60?
Yes, because in 60, what they did is, if there is an individual who has given a personal guarantee to a company,
then
they will go to NCLT.
go there.
Precisely. They wanted that insolvency resolution before a single firm. Therefore, subject to the provisions of section 60, the adjudicating authority in relation to insolvency matters of individuals and firms shall be the debt recovery tribunal having territorial jurisdiction over the place where the individual debtor actually and voluntarily resides or carries on business or personal works for gain and can entertain an application under this code.
Person has given personal guarantee in respect of to a company, then
Yes.
they will go under part chapter 6.
Yes, section 60. Now your lordship will see section 60 also.
No, that is not relevant. Because this I want.
That may be relevant because they are harping on a point as if there is a personal guarantee. Therefore, your jurisdiction will be NCLT. Now that personal guarantee which they say is not a guarantee deed executed by any individual. They claim that there is a partnership firm which is deemed to have given a guarantee. Therefore, the partners are given a personal guarantee. These are their statements. I'll point out to your lordship from their own petition. It is nothing but a clear mischief and abuse to just lodge a petition before NCLT. Now, please see section 16. Lord. Admitted possession, even before the arbitration, no individual is a party. Lordship can also make a note, admitted possession, no individual had executed any personal guarantee deed. And even the partnership firm has not executed any guarantee deed.
Even partnership.
The partnership is not executed. Partnership is party to the so-called loan agreement which they are relying.
Partnership is a party.
Party to the loan agreement. Section 60, my lord, I'll only point out that factor. Where it vests a jurisdiction insofar as the individuals.
Yes.
Section 60, adjudicating authority for corporate persons. And the adjudicating authority in relation to insolvency resolution liquidation for corporate persons, including corporate debtors and personal guarantors thereof, shall be the National Company Law Tribunal having jurisdiction over the place where this so and so. Without prejudice to subsection 1 and notwithstanding anything contained in the code, where a corporate insolvency resolution process or liquidation proceedings of a corporate debtor is pending before a National Company Law Tribunal, an application relating to the insolvency resolution or liquidation or bankruptcy of the corporate guarantor or personal guarantor, as the case may be of such corporate debtor, shall be filed before the NCLT. But this portion of liquidation or bankruptcy of corporate guarantor, personal guarantor was brought in by way of an amendment substituted in 6/6/2018. So this gives the jurisdiction if there is a cause as to a personal guarantee given by an individual in respect of a debt of a company. Now this, my lord, also doesn't say anything about a partnership firm. So therefore, my lord, the position of law today would be, insofar as partnership firm is concerned, the code is nowhere notified in any manner. And now this notification with regard to the personal guarantors for the corporate debtor that came on 5/11/2019, which your lord, I'm sorry, 15/11/2019. The notification your lordship will get at page 700.
Application under section 95 will go to which authority? Or
if it is in terms of a guarantee to a company, it will go to NCLT.
Go to
NCLT, National Company Law Tribunal.
otherwise in that
Otherwise, it will go to DRT, Debts Recovery Tribunal, which is not yet notified.
No. When it is filed,
yes,
95 application. So at the threshold, it will be dealt with by whom?
NCLT.
Individuals and professional.
No, my lord, it is not so. But I'll take your lordship to that also. I'll show your lordship that.
That will be dealt by whom?
That
Who will-
NCLT, please Please see 95, 96.
There is a dispute amongst you that where it should go. So that question will be decided by whom? Resolution profession.
If a
No, he
partnership
cannot.
concern is a debtor, then it goes before the debt recovery tribunal. But if it is a corporate guarantor, personal guarantor,
Pending all disputes about
NCLT, it goes
jurisdiction,
before NCLT.
where it goes, who will decide, what
NCLT.
is the.
Everything has to be decided by the RP on his report, and then it has to be decided by the adjudicating
Yeah, so
authority.
then after report, according to you, either will go to debt recovery tribunal or NCLT.
If the NCLT feels, my lord, the petition is not maintainable before it, my lord, it will relegate, it will dismiss.
Lordship, may I make one submission? There is small clarification requires for Lordships. The two adjudicating authorities which have been notified under section 179 and also 7(9), they are saying there are two sets of parties. I am appealing for Union of India members. Individual and partnership firm, they want to recover their debt. The jurisdiction is vested, not yet been notified according to my information, DRT. Other than that, if the company is a corporate debtor, so if they want to recover any money from other person or liquidate through liquidation process,
So why you are plunging in a private dispute?
well, no, I'm not entering. I'm just only legal position. Whether they have got a debt or not, it is between them to be settled in the
For Union of India.
Indian. I'm not entering into their factual aspects. I'm only making submission with regard to legal position as far as notification and adjudication authorities.
Who called upon you to make a legal submission?
Well, it's-
Anybody called upon you to leave?
I'm
Then
so
please
sorry.
sit down.
So-
We don't see any role right now for you,
No, no.
Mr. Union of India.
Yes.
Then why should you intervene within the dispute
I'm so
with the
sorry,
private
Manoj.
party
I'm sorry, Manoj.
and support any one of it?
No, it's not support matter. It's only legal position, nothing to do with their factual aspects. I'm so
It
sorry.
appear to be acceptable.
I'm so sorry.
I'm saying only acceptable, nothing more I am saying. Yes. If need be, we'll call upon you. But there is no need to intervene, and this is essentially a private dispute.
And absolutely.
And Union of India should not take any.
No, I'm not taking any stand on
Right,
any of the
yes.
either side, except.
If you need a, you will be called upon.
Absolutely.
Yes.
Two sections, my lord.
This
Lord-
change-
Lord, 94, your lordship, 95, no, 94 speaks about application by a debtor.
This discontinues the link. Yes, what you are submitting.
But I was saying that the adjudicating authority insofar as individuals and partnership firm is the DRT. Adjudicating authority for corporate persons as well as personal guarantor to such corporate person is NCLT. Now, even in terms of section 2, subsection 2 of section 60, which is the jurisdiction of NCLT, they use the word very, very clearly, personal guarantors. Partnership firm is not yet brought in. Partnership firm is not even notified. Whereas their case is in entirety saying that there is a partnership firm which is an executant to a document. Therefore, I treat them as a guarantor. The partners as a personal guarantors.
So you are saying that on the admitted or on the facts
Yes, ma'am. Yes, ma'am. I'll show your lordship those.
disputable, the NCLT is not the.
He's not having any jurisdiction.
Forum.
Yes.
But that recovery tribunal is jurisdiction forum.
It is also not there because not yet notified. That will come into place only if notification comes. That is where I wanted to show your lordship the notification which is at page 700.
Which notification?
That notification as regarding these personal guarantors. But that judgment which my learned senior had pointed to your lordship Supreme Court is challenging that notification as to personal guarantors being brought in. Now, please see, my lord, the notification at page 700. Page 700.
Page 700.
700. At 701. At 701. Notification dated 15th November 2019. In exercise of powers conferred by subsection 3 of section 1 of the Insolvency and Bankruptcy Code, the central government hereby appoints the first day December 2019 as the date on which the following provisions of the said code only insofar as they relate to the personal guarantors to corporate debtors shall come into force. Then clause E of section 278, 94 to 187, they have given the provisions.
So 95 is not in picture.
No, 95 is included, man. 94 to 187.
Shall come into.
95 is included.
But that is only in
only
relation to-
insofar they relate to the personal guarantors.
So what is the implication?
Partnership form is not yet notified.
No, that's right. But what is the implication of this notification?
By virtue of this, insofar as personal guarantors who are given guarantee for a company, 95 can be invoked and filed before the NCLT.
95 can be invoked.
Invoked and filed before the NCLT.
By others not.
Others not.
By others not.
No more.
So in that sense also the application is incomplete.
Yes.
What do you say?
There is an
about it?
absolute lack.
Keep in mind, not now.
Yes, there is an absolute lack of justice. Now, factually, let me show your lordship as to what is their application before the NCLT. Please see this petition, which starts at page 100.
Yes.
Page 100 is their petition. I will show your lordship only the relevant. I will not trouble your lordship much. Please come to page 102, paragraph 4. 102, paragraph 4.
1 second.
That stated in essence, a number of agreements were entered into among the financial creditor applicant on the first part and the corporate debtor as well as affiliated concern of the corporate debtor.
One second.
I'm sorry.
Page 10.
102.
Yes. Paragraph 4.
Paragraph 4, yes.
Yes.
That stated in essence, a number of agreements were entered among the financial creditor applicant on the first part and corporate debtor as an affiliated concern, as well as an affiliated concern of the corporate debtor, namely so-and-so, which is a partnership firm. On the other part, the details of which has been provided hereinafter. The substructure of the loan agreement dated 6/11/2012 was such that Mr. So-and-so had undertaken to stood as a corporate guarantor and the partners of the aforesaid firm, personal guarantors, respondents of the present application, had accordingly undertaken to serve as the guarantors in respect of the loan availed by the corporate debtor, principal borrower. In this regard, the financial creditor, with great respect, intends to draw kind attention of the tribunal that although so-and-so would also qualify to be a corporate guarantor, yet since it is settled position of law that any partnership concern constituted the provisions of Act by virtue of law is indispensable from its partners, and as such the liability of the partners in any partnership concern is unlimited. Therefore, all the partners of Manyata who had been arrayed as respondents would qualify to fall within the purview of personal guarantors, since the partnership concern is indispensable from the aforesaid partner. In essence, this is their case. No personal guarantee given by any individual. An agreement which they term it as a loan agreement is executed by a firm. Therefore, they claim the partners are given personal guarantee. There is a definition of personal guarantor. Section 522. Now, this personal guarantor is also defined under the code, which is very interesting. If it remained undefined, probably there can be some consideration of what they seek to say, that under the Partnership Act, as a partner, you are eligible. No, but the code defines it. Please see section 5, subsection 22. Subsection 22. Section 5 is definitions under part 2, subsection 22, my lord. There is one set of definitions in section 3.
Twenty.
22, my lord, subsection 22.
22.
Yes. Personal guarantor means an individual who is the surety in a contract of guarantee to a corporate lender. Now, on this notification which came into effect on 15/11/2019, they also brought in rules. Rules also, my lord, defines who is a guarantor, which also says means a debtor who is a personal guarantor to a corporate debtor in respect of whom guarantee has been invoked by the creditor and remains unpaid in full or part. So 15/11/2019, when notification was issued, bringing personal guarantors within the ambit of the code, there are specific rules framed, regulations framed. Rules also defined guarantor, which said means a debtor who is a personal guarantor to a corporate debtor and in respect of whom guarantee has been invoked by the creditor and remains unpaid. Now, in all these substance, in terms of their own application before the NCLT, their own description, and the only document which they relied, your lordship will also have a look at that document, not which is there at page 685. Only document. Page 685.
What is that?
This is the document they rely.
Loan agreement.
Loan agreement. Now, please note, there will never be a word as a loan agreement here. This agreement executed on the 6th November 2012 between Manyata Infrastructure, Manyata Reality. Now, this second party is the partnership firm. A partnership firm registered under the Partnership Act. Hereinafter referred as the owners. Then, not the appellant before lordship, who is known as developer. The agreement does not even say not lender, debtor, or creditor, borrower, developer. Then over the page 686, it refers to various agreements, joint development agreements, so forth and so on. Please come to 687, paragraph 2. 687, paragraph 2. Paragraph 2, my lord. It says, as the said sum of 40 crores was paid in advance, having been treated as interest-bearing refundable deposit from the developers to the owners with effect from 1st January 2011. Sorry, 687, paragraph 2. It and shall carry simple interest at the rate of 24% per month, which payable to the owners commencing from so and so, subject to conditions. Now, other than this, lord, this is the only agreement. It ends with 688. It nowhere uses a word as a loan agreement. It doesn't speak about any guarantee. But my friend wants me to read paragraph 5, which is at page 688. In the event of failure on the part of the owner in complying with the conditions precedent in terms of clause 2 above, before 31st March 2013, in such event, the second party shall become entitled to seek repayment of the amounts treated as interest-bearing refundable deposits under this agreement forthwith without any further delay, and the owner shall be liable to prepay forthwith to developer the entire sum of 40 crores. So what was received as interest-free security deposit was sought to be treated under this agreement as an interest-bearing deposit if you fail to comply with certain conditions. In paragraph 2, they say that I have paid you 40 lakhs in advance. You are failing to comply something. Therefore, let us treat this money of 40 crores as an interest-bearing deposit subject to your complying with all conditions. And in paragraph 5, they say this should be done before 31st March 2013, failing which you have to repay this money with interest. There is no personal guarantee. There is no guarantee whatsoever. an agreement where two parties join as landowners, the other party joins as a developer. Now, on this basis, my lord, can it be held that they will be entitled to maintain a petition before NCLT?
So what did they say in page 102? Let us see. 102 you read. What did they say?
Page 102, your lordship will now see, my lord. Page 102, paragraph 4. They said that stated in essence, a number of agreements were entered into among the financial debtor applicant on the first part, corporate debtor as well as affiliated concerned corporate debtor, namely Manyata Reality, which is a partnership firm, on the other part. The details of which has been provided hereinafter. Substructure of the loan agreement dated 6/11/12 was such that Manyata Reality had undertaken to stood as corporate guarantor, and the partners of the aforesaid firm, personal guarantors, respondents, have accordingly undertaken to serve as guarantors in respect of the loan availed by the corporate debtors. None of these are there in the agreement. This is the only basis for them to file. Now, what consequences happen, not as I pointed out to your lordship, 96 sets in, 95, now your lordship will see 95, 96.
This partners, this firm is a corporate.
That's
The firm is a corporate debtor, guarantor.
no, my lord.
No,
That company alone will qualify to be a corporate debtor, not the partnership firm.
not the partnership.
Not the partnership. Partnership firm is specifically dealt with in part 3. And insolvency resolution against the partnership firm in terms of part 3, the adjudicating authority under section 179 would be the DRT.
Corporate guarantor is also defined
Yes, ma'am.
by way.
Yes, ma'am. Defined. Corporate person is defined, corporate debtor.
Firstly, a corporate person
Yes, ma'am.
who is the surety in contract
Yes,
of guarantee to a corporate debtor.
yes.
So then how this averments in paragraph 4?
But that is how they have filed, that is how they are claimed. Now, the only thing which they have done is filed it before NCLT, even before any scrutiny can happen. Go before
Says
the
that
tribunal.
Miss Manyata Realty would also qualify to be corporate guarantor.
Guarantor. That is what is their statement. Agreement doesn't speak anything. But if two persons have joined in an agreement, jointly making an obligation as a landowner, that I have received some advance, I will treat it as instead of interest bearing, we will treat it as instead of interest free, it will treat it as interest bearing. Now, what consequences? But only two more minutes, I'll try to finish. 96 says, where an application is filed under subsection 94 or 95. 94 is filed by the debtor himself. 95 is filed by a creditor. Now, 95 subsection 2 specifically speaks about partnership debt. 95 subsection 2 speaks, a creditor may apply under subsection 1 in relation to any partnership debt. That is also defined. Now, there again 96 says, so therefore, where an application is filed under section 94 or 95, an interim moratorium shall commence on the date of application in relation to all the debts and shall cease to have effect on the date of admission of such application. Because my friends were trying to point to your lordship as if it is only for 10 days. No. This interim moratorium will continue till the admission happens. Starts on the date of filing itself. Now, dehorse my arbitration, my lord. Why should these partners suffer this? My bankers are being notified. My other creditors are being notified. If moratorium steps in, no individual can do anything. I am completely being crippled. For them, the object is only to stall the arbitration. For me, it has got a serious effect. It is amounting to a civil death. So then it says the creditors or the debtor shall not initiate any legal action or proceedings in respect of any debt. Where the application has been made in relation to a firm, the interim moratorium under subsection shall operate against all the partners of the firm as on the date of application. Then comes note 97 regarding appointment of resolution professional. So in the process, if something is filed in the NCLT, a scrutiny happens, numbered and comes before the NCLT. But NCLT at the first instance appoints an RP. That resolution professional, not as they said, will file a report. And on that report, Supreme Court said the debtor will have an opportunity to object if he has got any case. Adjudication happens, admission will be notified. So till such time, 96 will be in operation.
Will be in operation.
Will be in operation. Now, my concern is that when the NCLT does not have any jurisdiction, when by a means of such statements, even without a guarantee deed, somebody files an application, why should I suffer? This is on the point of complete lack of jurisdiction. Partnership firms is not even notified. Only two more things I'll point out. Not if your lordship permits me, can I place some documents as to what happened in the earlier writ petitions where they tried to stall these proceedings? In one writ petition, Lord, this honorable court not dismissed with a cost of 25,000. They took it to the Supreme Court. Supreme Court also dismissed. There, their claim was by virtue of a stay which was there in this.
The 95 application again we are asking. Once filed.
Yes.
It will go to whom? Clerical authority.
Yes. The registrar of the NCLT will scrutinize and number it.
But it's time bound. I'll with the permission of
my friend can wait.
With the permission of my friend.
I'll finish it, not my friend can say whatever.
Time bound.
Now,
I'll only show lordship.
Is compartmentalized in such a way.
2 documents and 2 judgments. If there is a lack of jurisdiction, can the High Court entertain that? Starting from 1950s, we have judgments on the point. 2 documents, 2 judgments. If the lordship permits me, can I place the documents as to the what happened in the earlier round? I will not trouble your lordship an entire thing. Please see page 74 alone.
Can a registry say that this is without jurisdiction?
RP
It becomes a big questionable point. RP cannot say.
Even
Absolutely false. RP can only examine on the debt.
We are the threshold. Registry or clerical head of the department of the filing center. Let's say in a
they may raise a question on maintainability for them to explain.
Can they?
Maintainability they can raise. Not how this petition is maintainable against a partnership firm. The registry on the signature of the registrar can raise.
It is a part of adjudication.
It is
so
like
then they make an explanation to that objections. Then it has to go for an adjudication before the members of the tribunal.
It's like filing a writ appeal against the very registration of the writ petition before the scrutiny, the receiving branch. Even it goes before the scrutiny branch.
See, can this the registry of our High Court?
I'll answer the question.
Registry of our High Court can say that this petition is filed after 10 years, therefore is barred by delay. Can registry?
No, there is an added mechanism here. There is an added mechanism.
But they cannot adjudicate.
There is an added mechanism here.
No, they can refuse. Can they refuse to accept the filing?
No, they can raise it as a.
That is the whole point.
There is an added mechanism here because the RP steps in. He will submit the report after giving opportunity to the petitioner and the respondent.
But and they are saying that you are manifestly without jurisdiction.
That, my lord, that
I'll complete my friends can.
That calls for examination of the document.
Will not be
Yes,
yes, but I'll just complete. Your lordship will see page.
How much time will take?
Not another 5 minutes. I'll finish.
No difficulty, but we'll postpone.
I'm sorry, we are taking a longer time.
No.
5 minutes.
We don't want to complete because we are in the process of thinking. Therefore.
Yes. Please have a look at document 7, which is at page 74.
Page 74. Yes.
74. And on order dated 5th April 2024.
Yes.
By a bench of this honorable court. The very same appellant was a petitioner. But Lordship will only take for consideration one or two paragraphs. At page 94, there's all other factual things, not, I don't want probably a Lordship, at page 94, paragraph F. Paragraph F. It is relevant to note that the respondent, page 94, paragraph F. It is relevant to note that the respondent was before this court in WP number challenging the NCLT proceedings initiated by the petitioner under 95. In the said proceedings, stay of the arbitration was granted on 2012 and stay of proceedings was in force till 6/3, the date on which the writ petition was allowed. Admittedly, arbitral proceedings was stayed for about 78 days. When there was a stay of proceeding by arbitral tribunal could not have proceeded further. But just fact, your Lordship will take note. Then come to over the page, 96, paragraph G. From the fifth line. From the order sheet of the arbitral proceedings, it is seen that the petitioner, who is a respondent before the arbitral tribunal, took more than 3 to 4 adjournments to file its objection statement and also to file counterclaim. Thereafter, it took several adjournments and also sought extension of time to file sub rejoinder. Admittedly, the arbitral tribunal entered reference on so and so. Since then, the petitioner has filed 6 writ petitions challenging different interlocutory orders passed by the arbitral tribunal. With all these reasonings, ultimately for the reasons recorded above in the above circumstances, appropriate to dismiss the writ petition with cost of 20,000 payable to so and so, so and so. Now, this was challenged, my lord, by them before the Honorable Supreme Court. But that order, your Lordship will get at page 101. I'm sorry, 101 is the special leave petition. Order is at page 156. Page 156 is the order of the Honorable Supreme Court, as against the order.
156.
156. Arising out of the impugned final judgment and order dated 5/4/24, which I read. Page 156. Yes, which I read. So, as against this. At page 157, last but one paragraph.
Now read that again.
Yes.
F and G.
Yes, ma'am.
F page 94 and.
Yes. Page 94. F, it said, it is relevant to note that the respondent was before this court in WP number 26977 of 2023, challenging the NCLT proceedings initiated by the petitioner under section 95 of IBC. In the said proceedings, stay of arbitration proceedings was granted on 2012 and stay of proceedings was in force till 6/3, the date on which the writ petition was allowed. Admittedly, arbitral proceedings was stayed for 77 days. When there was a stay of proceedings with the arbitral tribunal, the tribunal could not have proceeded further. But this was on a context that they claimed that the mandate is now over because 12 months is over.
This is about the limitation.
Yes.
Then what is the relevance?
Then paragraph, page 96, paragraph G. Fifth line. From the order sheet of the tribunal, it is seen that the petitioner who is respondent before the arbitral tribunal took more than 3 to 4 adjournments to file its objection statement, also to file counterclaim. Thereafter, it took several adjournments, sought extension of time to further rejoinder. Admittedly, arbitral tribunal entered upon reference. Since then, the petitioner has filed 6 writ petitions. Why I am pointing out, Lord, the entire exercise by them is not for some kind of insolvency resolution against me. Exercise is that I need some means by which I will seek the arbitration to be stayed. So file a 95 petition, because even before scrutiny, the moment filing happens, 96 says interim moratorium. File a memo before the arbitral tribunal and say that you have to keep your hands off. That is what they did. Now, when I came for a challenge in this before this court in the writ petition, They filed a petition to stay the arbitration. The learned single judgment by an all sense said that, all right, let me decide, you keep off. Thereafter, they claimed that the mandate of the arbitral tribunal is over. Considering all these things, my lord, as to their conduct, this honorable court dismissed this writ petition with a cost of 25,000. They took it to the honorable Supreme Court. But Supreme Court also dismissed it, confirming whatever findings which the tribunal which this court had given. That Supreme Court order is not, which I read at page 156 and 157. Finally, only one judgment, not. I will read 4 or 5 lines, though it's a very lengthy judgment. I will just read that 4 or 5 lines. You have one copy. Your Lordship will come to page. But I'll take a Lordship directly to the bookmarked page. Not for convenience, I just made a mark, which is page 109. Starting from paragraph 52.
52.
Yes, ma'am. Please come to paragraph 53. Not about 52, my lord, it records as an issues whether the application for a writ of prohibition is maintainable. Then under these particular statutes, paragraph 53, my lord, about 15 lines from the bottom. About 10 lines from the bottom, on the right hand side, it starts as writ of prohibition is issued whenever a subordinate court or tribunal usurps jurisdiction which does not belong to it, and when that has been shown, the issue of writ, though not of course, is of right and not discretionary. The point to be determined, and so on. So this principle, which starts from the year 1955, as to the High Court jurisdiction in 226 issuing a writ of prohibition against a subordinate judiciary or tribunal which lacks jurisdiction. But this has been followed by many judgments. But in fact, I have got a compilation. If the Lordship feels not, I can pass it on the compilation of judgments also. Therefore, just to summarize, in law, insolvency as against partnership firm is not notified. Therefore, you cannot have a case that a partnership firm is a debtor, therefore I will initiate. Secondly, what was notified is the personal guarantors to a corporate debtor, which specifically under the code, there is a definition of personal guarantor as to an individual who had executed a deed of guarantee. Under the rules, guarantor is defined, saying that there should be a deed of guarantee, there should be an invocation of guarantee. In absence of all these things, no petition would be maintainable. Therefore, there is absolutely no jurisdiction for NCLT to entertain such a petition, which is not even notified till date. Under section 179, the partnership debt is only before the DRT, the day it gets notified. On facts, by their own statement, there is no guarantee deed given. A so-called agreement between a landowner and developer is being termed as a loan agreement, and no covenants as to any guarantee specified there. But they are trying to read it that there should be a deemed guarantee and you are liable. And therefore the partners are liable, which is absolutely a far-stretched imagination. And all these things is an exercise only to stall the arbitration. I rest with that. I am grateful for your order.
The rejoinder on the other, whenever both of you want.
Tomorrow. We will not take, my lord, more than 15 minutes. But we'll conclude, my lord, this is on a very narrow, my lord, issue.
In the entire country, my lord, not a single petition is filed. The problem would be
Like tomorrow. Tomorrow what date? Tomorrow we have bench. So we bench.
Friday.
Tomorrow.
Can it be day after tomorrow?
That is better, so that we have breathing time.
I had to travel.
Day after tomorrow is 21st,
21st.
31st.
Friday.
Friday.
Friday we have bench. No, Friday.
Good, so great.
A pleasure. We need to take permission to take these documents.
What is the name of it?
Lord, may I just make one prayer, my lord? Lord, item number 28, my lord, today. Can I pray for that matter for tomorrow, my lord? Lord, in the afternoon, my lord, I have to be before the NCLT, my lord. Even this matter, my lord, is a bit of urgency.
28
Lord,
is
today, my lord, kindly have it tomorrow.
some contempt petition.
Yes, my lord.
If no urgency next week.
No, my lord, there is urgency, my lord. Today, my lord, I have to be before the NCLT. Tomorrow, my lord.
Tomorrow.
Seek short accommodation. File the review petition.
May I seek your lordship's indulgence to mention, my lords, item 73, which is there on board today. It's very unlikely as it happened last week. Lords,
Is it about?
noticing the urgency matter was listed last.
About?
Doctrine
Nomination.
of pleasure, Manoj, we have been arguing. Doctrine of pleasure, we have been arguing. Only this pertains to Rajiv Gandhi University, my lords.
My lords have made an interim order, which, my lords, protects the petitioners. But then by that, my lords, the operation of the statutory provisions have come to a standstill. Want an observation from the court that it doesn't stop the statutory operation.
My lord, there are different statute, different, one is with Honorable Justice Krishna Dixit.
Different bench.
That is on
25th, yes.
25th. No, that may not have bearing in this case because in this, by virtue of the single judge and the division bench, he has completed his period also. My lord. The term is already over.
Then what surveys?
Does not survey, the term is already over.
Because of the interim order, they are continued beyond the statutory period. So all that we want is a clarification that the statutory provisions would operate, nothing more than that.
That can be done.
That's
That
only
is-
limited because that's
But
only
I would
limited
submit-
purpose.
Term is not over. I don't know. They want to give a retrospective effect to a
When will
appointment.
you hear it? When will you hear?
Anytime, let's 2:30, your lordship may have it on some day, so that I am not opposing that. But
We
to
just
say
want
term,
this
I will point
clarification.
out that aspect.
We'll show, my lords, that the statutory provisions are.
Select your date and we'll proceed.
I have no issue.
Lordships have it tomorrow, Monday,
So is not possible. Day
Monday,
after tomorrow
Tuesday,
is
my
not
lords, otherwise, my lords, there's a
Any date,
vacuum.
your lordship may kindly fix any date.
26th or 1st, whatever. Choose.
26th, my lord.
26th.
Please.
26th. Give me.
Increment extend ಮಾಡಿಸ್ಬೇಕು.
Please, ma'am. 2:30 on 26th, my lords. Because only thing we'll point out, my lord, two aspects. One is whether the term is over, my lords. That's the main
Order
thing.
may kindly be extended.
On 26th or at 2:30 on 26th, whichever is earlier.
Please. Very well.
I'm sorry. What your lordship think it will reach much earlier.
Interim order may kindly be extended till then.
Interim order shall continue to operate till the next.
Please.
Careful to.
List.
Mr. Phanindra, you are the petitioner in that matter. So remove the office of the.
But 73.1, I am not appearing. Sir.
But
That
whatever
somebody,
it is, there will.
only in 73.
We'll see on that.
I'll inform the council on record.
In fact, serial number 47 is also regarding under the Beggars Act. 47 is also doctrine of pleasure, but under a different statute. My lord. That may
On the same day.
on the same day.
My lord, 47, my lord, both the matters can be taken up on 25th, my lord, or 27th, my lord, because senior counsel has some difficulty on 26th.
So then 27th.
Please.
So then let it go to first.
Please.
First.
So he wants it on 25th, my lords, it can come on 25th.
25th, there is a different bench.
all
So we might,
Very well.
it will be uncertain.
Lords,
My lord, interim order may kindly be extended in 47 also. Great.
That 47 also you give. 7 and 47 is kept on first. This is kept on 26. First. One is on 26th, the other on first.
On 27th, your lordship directed the concerned person to file an affidavit. Their claim that, my lord, it is a deemed forest. I have not received any affidavit so far. my lord.
We have not filed affidavit.
Not filed, not going to file.
Filed affidavit. I'm yet to receive instructions. I'm yet to receive instructions.
You are yet to take it.
The last may kindly peruse 154, page number 154.
That if my learned friend is arguing, my lord, I will argue the matter.
No,
My
no,
lord, is
I'm not
replied.
No,
Yes.
no,
Showing the page is not argued.
After seeing that only, your lordship directed to file affidavit.
no, no.
50. But you are afraid of your learned friend's argument.
No, 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 I am not.
Then let. One
154, last 4 lines. Special Deputy Commissioner, the
154.
154 is
Page 163.
163. None
Sir, 150 is some notice. Is there?
No, no, it is 163.
163 is it?
Replied.
You are showing what?
Last page.
This is the
Reply to the legal notice.
It is a legal notice.
reply to the legal notice by senior geologist.
Same you are showing.
Yeah.
150, yes.
The last page, Lord.
Yes.
Special Deputy Commissioner, the land has full extent, the 400 acres of deemed forest area that can be identified by conducting joint survey along with the Revenue Department, and joint spot inspection is in
154 or
progress.
Page 154.
There is some
163
mistake in
minutes.
page number.
Last page of the.
Last page.
Yes, 163.
163, all right. In the meeting of district regulation.
In the meeting of thereafter, Lord, the special order of the Special Deputy Commissioner, the land has full extent. The 400 acres deemed forest area that can be identified by conducting joint survey along with the Revenue Department, and joint spot inspection is in progress. Till receiving the report, decided to hold the application temporarily. By this way, the order of the Honorable Court with a reference number 1 is complied. The same is sent to your information. His translation may not be happily worded, but the gist of it is, Lord, it is in progress. Your Lordship may grant us 3 months' time, by which time, Lord, we will identify whether it is comes under the deemed forest or not. Then we'll decide, take a decision. Unless this joint survey is conducted.
3 months is too long. We'll give.
But several surveys are already conducted. Range forest officer has submitted a report in the very same case, is outside the deemed forest.
While this court passed order on 27/5/24, inter alia requiring the competent authority to file affidavit, placing on record its stand about the land to be treated as deemed forest or not, and other about other developments. When the petition comes up for consideration today, learned government advocate Mr. Mahendra invited attention of the court to the reply to the so-called notice given by the given to the petitioner by Department of Mines and Geology, which inter alia mentions there in the court page 162 and 163. Full stop. It was therefore submitted that the process of undertaking survey to identify the land and to ascertain the status thereof is underway. That's further time will be needed to have the final instructions. What is stated in the reply to the legal notice may be placed on record by way of affidavit. Full stop. In the such affidavit to be filed before the next date, the progress of the survey, and if the result, if any, is available, shall also be placed on record. Put upon stand over to 21st August.
survey is already 3 times is conducted and it's found that it is outside that area which is earmarked forest.
All right, you don't want 21st August, 28th August.
There is a division bench judgment of this court, my lord, held, my lord. This land is not a deemed forest.
Not convenient.
No, it's covered by your lordship. judgment.
28th August, not convenient.
It will not come at all. But
Not
that's a,
convenient.
well, no, I'm only just, well, let it be on 21st August. I'm sorry, well, I did not follow. Let it be on 21st August.
21st.
Please. I'm sorry, well, I didn't follow.
Still number 15, consideration of complaints in contempt matters. Mr. Raghavendra Ji,
I'm appearing for the accused number 1, a week's time for filing my time.
All. 11th July.
Great.
Still number 16, Mr. Shankar Narayan Bhatt.
Compliance affidavit has been filed. Compliance affidavit has been filed. my lords.
Where is the complainant?
Shankar Narayan Bhatt.
Some order is passed on representation.
Please, my lords. Order has been passed and it's been produced.
Page 8, annexure 2.
Page 8 of the affidavit. my lords. Their representation was to enter the, make entries with respect to Kata, my lords.
Record is not available.
Lords, records is not available and it is a government Gomal land. The complainant is the purchaser of the land from 3 vendors who claim to be the grantees. my lords.
The present will dispose.
Please.
Tomorrow at 2:30. Since learned additional government advocate
Pramodini.
Pramodini Kishan submitted that the order is complied with, and he drew attention of the court to the affidavit compliance from awaiting the presence of learned advocate for this complainant in vain, to be listed on 20th at 2:30.
This is number 17. R. Srinivas Gowda.
For the complainant.
I appear for the accused, my lords. The compliance, we have complied with and we are, the road has been constructed, my lord. Please pray for some time that we may file an affidavit to the effect and as well as photographs.
So and so appear
Well,
through video conferencing to
So,
that the time may be granted to enable her to file the compliance affidavit and to
Please.
show the progress of the compliance, tender or
so far as
9th
accused
of,
number 3.
9th of July.
Please, my lords, much obliged.
Number 18, Mr. Balakrishna Mar.
Yes.
The order has been complained by the accused number 2, madam.
Complied with?
Yeah, complied.
They
Learned
filed a
advocate for
compliance
the
affidavit
complainant
along with the
so and so
compliance.
stated to the order brought under the contempt jurisdiction is complied with. Learned additional government advocate, Ms. Pramodini Kishan, confirms the compliance. The aforesaid review, nothing survives in the present contempt petition is accordingly disposed of.
This hearing on interlocutory applications, seal number 19, Mr. Ramatullah Kotwal.
Hearing for the petitioner, your lordship. Filed a recall application.
So it is dismissed.
Earlier, it was dismissed for non-compliance of office objection, your lordship. Now all the office objections are complied.
So application is filed IA2. IA2 of 2022. It appears that by virtue of order dated 13/10/22, writ petition came to be dismissed for want of prosecution. Present application paragraph is filed seeking restoration of the same. Paragraph advancing the reason for unable to remain present when the petition was called out. It was stated on oath by learned advocate for the petitioner that he was engaged elsewhere and had also a case before the apex court. Therefore, he was prevented from appearing. It was stated that before the time his junior could reach the court, the case was already called out, and the petition was dismissed for want of prosecution. Full stop. It cannot be said, it could not be said that there is an element of culpability in not remaining present. Full stop. When the absence was found to be bona fide, the dismissal ensued has to be set aside and the petition deserves to be restored to enable the petitioner to contest his case on merits. Application is allowed. Writ petition number 7545/22 is restored to its original file with all subsisting orders, if any. With all subsisting orders. Next.
Lordship may kindly issue notice to the respondents.
We'll post, the petition may be posted on 9th July.
Please, Your Lordship.
I'll take notice for respondent 1 to 4, my lord. 1 to
On
4
that day.
and 6.
Madam, on that day.
Please.
Much obliged.
Number 20, Nayantara BG.
I appear for the petitioners, my lords. Pray for 2 weeks' time to place our report before this honorable court.
Learned Counsel, Ms. Nayana Tara BG, prays for time, stand over to. Place for time to place on record the report. Stand over to 12th July.
Much obliged, my lords.
Yes. 20, some councillors prayed for time to place on record the report.
The matter is keep on adjourning, my lordship. In so many days, it's getting adjourning, my lordship.
He is filing some report.
So not requirement under section 50 subclass 1 of JNWC Act.
On next day, we'll consider.
Please, Your.
Silumbar.
I applied for increasing application.
You can argue and come. Impleadment will consider on that day. Nothing to do with the case.
Matter is urgent, madam.
So we'll permit you, madam. If you are interested party, will permit you. If you are interested party, will permit you to make submissions.
For the judiciary, benefit of the judiciary.
Yes, yes.
So, they ask much time.
Maybe. They're asking time to file some report. Yes, 12th of July.
Question number 21. Divya HN.
Appear for the petitioner's counsel.
Respondent.
Appear for the petitioner's counsel, my lord. This matter was heard before the vacation. The petitioners were heard regarding the medical college.
One submission
Medical
before they start. They had mentioned that an affidavit was not filed in the first matter.
My affidavit has been dispatched
That
today, my lord.
student was
Yes.
Yes, my lord.
admitted at last.
Yes, my lord. Yes, my lord.
So what is the today's status of admission, etc.?
My lords, I appear for my lords respond.
They're all
in-
studying.
In
They're
terms
my
studying,
lord.
my lords, they have given the exams also. I appear for college. my lord.
No, my lord,
Last
this,
year
this
matter.
student,
This was to be heard.
this
by-
student he appeared for the two exams on the basis of a interim order passed.
remote is past year.
Interim order is passed to write the exam. Results have to be declared. My lord. If results are declared and he is allowed to go to the second MBBS, the matter can be heard anytime in future also.
It can be heard on 24th,
Please, my lord.
24th.
Uh,
This is students matter, will try to take.
Pleadings, my lords, was not complete, my lords, in their matter.
In the pleadings, that question does not arise, my lord. Itself.
If it doesn't reach,
Please,
by,
ma'am.
if doesn't reach in the first half, then please remind us. We'll try to
Please,
take up.
please.
Please, my lord.
Otherwise, either way will decide. So
Please.
Please, my lord. Please,
it was heard twice, but now we are new bench, therefore
please, my lord.
put an end to it. 24.
Saturday is a working day, my lord, this 22nd. I'm told. Please,
22nd.
22nd.
22nd, we have, my lord, we have part-heard matters in other courts.
So 24.
Please, my lord.
22, to Madhusudan Adiga.
I appear for the petitioner. My lord, I appear for the petition. I appear for the
One is 1
petitioner.
to 5.
I appear for the petitioner. There is an impleading application filed. Why not? I have no objection. That may be allowed. I'll carry out that amendment and file amended petition. Pardon? An impleading application has been filed by not. I have no objection. That may be allowed.
For amendment.
Impleading application, Order 1 Rule 10.
Interim application for?
Impleading, my lord, and the order one,
Pleading.
yes, the Waqf board wants
Who
to
are you?
implead.
I am for the petitioner.
Lord, I have
Who is-
filed. Lord,
you
can I
have filed?
submit?
Who are you?
Lord, I am the board, Lord, Waqf board. The property against which this PIL has been filed is a notified Waqf property. He ought to have made as a party without making as
So
a
what is
party.
what is the PIL?
Lord, PIL is seeking for a direction that this is a protected monument under the Archaeological Act. And then there is some madrasa classes going on that should be immediately stopped. It is admittedly a Jummah masjid. And my lord, there is this petitioner doesn't stay in that village. He has no relatives there. He doesn't say what is his cause of action, why is he protecting, why is he against only a madrasa that is being conducted.
So
No
today-
averments in the petition.
Today we allow the IA?
Completely motivated.
We allow the implement application.
The completely motivated petition is what my humble submission would be. But
So
let
that
him
is
serve a
IA
copy, we will file our
IA
objection.
1 of 24.
Heard learned counsels for the respective parties. The the present application is file seeking impleadment. Full stop. The applicant happens to be the Karnataka State Board of Hookups. Full stop. The parent proceedings of the petition are public interest litigation wherein, the petitioner has prayed that the Waqf property deserves to be declared as protected monument under the Protected Monument Acts, Protected Monuments Act. Full stop. With regard to the subject matter of the public interest litigation and the status of the applicant, it could not be said that the applicant is a stranger to the controversy. It could well be said that the applicant is interested in the subject matter as well as the outcome of the petition. Therefore, it is a necessary and proper party who could be joined. Full stop. Resultantly, this application is allowed. Karnataka State Waqf Board is permitted to be added as party respondent in the writ proceedings. The cost title of the petition shall be amended accordingly. The impleadment of the applicant shall be at its own cost. So when shall we keep?
Any date, my lord.
Application is allowed and disposed.
Any date to the convenient to the court.
Saturday,
I'm ready.
Saturday, 22nd.
Any date convenient to the court.
If you can give
That
me
is
a copy
convenient.
today, we will,
No, I have to carry out the amendment and then give you. I have to carry out the amendment and then give them. a copy.
since my lords are having it on Saturday, it may be
Is it-
appropriate. He gives a full copy today, we can assist the court better.
Some other day,
No, my lord, 22nd, we are ready, would like to
I'll
finish
carry,
it as early as
so
possible.
Saturday.
Very well, we'll come on.
I'll
Friday.
carry out the amendment and then give the copy. Macho.
It is formal. We'll go to the main.
Very
Obliged.
Non-filing in contempt matters, seal number 23.
Lord, I appeal for the
Fatima,
respondent. Lord, direction
Lord,
was to
last-
consider the representation of the complainant. Lord, we have considered the representation based on the representation as far as the order passed by this honorable court. We have issued a notice, show cause notice to the other side as to why your lease in respect of a civic amenity site should not be cancelled. Not made.
Because last
I pass
occasion, if
on
you're,
the-
on the last occasion,
So what is not decided?
Lord, we have now issued an endorsement to the CA site allot. There was a CA site which was allotted to the Lord and allottee. Subsequently, my lord, certain discrepancies were noticed by the BDM. My apologies, my lord. I should have translated. I'll furnish the translation copy. Lord. Lord. Now we have called upon the person CA site allottee for why asking him to why you are cancel
This notice issued to whom?
Lord, this is issue to Lord Chaitanya Samarpana Welfare Association.
Or
Lord, there was an allotment in his favor by the BDA, Civic Community.
so this Samarpan Association will offer some site to you, which you will not allot to the complaint.
not
No,
at
Lord,
all.
we are still not allotting it to them because there is already an allotment in favor of the third party, of which we have to cancel. Lord, then subsequently, a decision will have to be taken whether that
But
site
the-
can be allotted to this complainant or not.
But similar submission was made on the last date of occasion
The matter was listed saying that they are deciding the mode of handing over and then it will
No,
be
no, no.
handed over.
No.
But now they are producing a show cause notice issued to the builder saying that it is in compliance of whatever is filed. How
But
can that be? I'm not
I-
able to understand. For
I-
2 years, they sat on it saying that show cause notice is issued just recently to the builder. That does not answer my grievance, my lord. In fact, it is dated 15/4/2024.
But the allotment in favor of the builder was not a subject matter of a writ petition. That was never challenged before the honorable court.
What you are supposed to do is to,
Consider the representation. We have considered the representation,
that.
issued a notice to the builder,
it is now
calling
considered.
upon him to why you sure not there is an allotment that has to be cancelled in accordance with law, my lord, after giving him an opportunity of hearing also. That we have done.
We are not satisfied with this.
Not
There are ways and ways to meet the contempt.
No,
This is not the way. That much we can say.
Lord, Lordship may then grant me a month's time, Lord. By then I'll complete the procedure and come back and report, Lord, because I'll have to call upon him for hearing.
The
And then
compliance
pass-
affidavit is filed today by learned advocate, Mr. So and so, so and so. Murugesh Chatri. You are Murugesh
Murgeshwi Charat.
Charati, for the respondent. However, the court is not satisfied with the affidavit. Also, it could not be said that the order passed by directions issued by learned single judge, which was only for passing appropriate order upon the representation of petitioner, could be said to be complied with. Also, further 2 weeks is granted to the complaint, to the respondent to comply with the directions. Also, failing which the court will be compelled to take a stern review.
Great.
Send over to 12th of July.
Please.
Number 24, to Devendra Payach.
Is not. So put up on 4th, 5th August.
Number 25,
Lord, seeks a
Complaint.
short accommodation to file my reply in this case. please.
Pardon?
Seeks a short accommodation to file my reply in this.
Short accommodation, 19th July.
Grateful.
number 26,
I appear for A1 in this matter, my lord.
I appear for.
Pray for a week's time to file my reply, my lord. In fact,
Pray for
we're in the
some time.
process of considering the representation, my lord.
Will
We'll
grant
just
time.
consider it and we'll file our complaints.
Yes, please, Short have it on.
23rd July.
Complaints are going to return in the next week.
Wait
next
for-
week, but Already is considered. Already is, yes, please, 23rd. Much all. Obliged.
number 27,
And for the
by
complaint,
Rajendra Prasad.
For
do
the
not
accused.
complete the order passed by this honor. There is a specific direction, my lord, that is in page number 38. They have to constitute the committee.
Committees for.
So far, they have not constituted.
I pray for 2 weeks' time in this matter.
Learned
It's a
additional
whole batch of
advocate.
matters, your lordship. The state has to take.
Next additional government advocate prays for 2 weeks' time. Mr. Jafar Shah prays for 2 weeks' time, stand over to 23rd July.
Number 28 urgent, number 29. Mr. Chandrasekhar Swami. 29.
Please, ma'am. Paper for complainant.
This case,
Complainant has filed the application under section 28A.
granted, I file my objections along with the affidavit. Already proceedings is going on. So I'll file my affidavit along with the process. Already we have filed an application and consider that application before the tribunal of the SLO, Special Land Acquisition Officer, is pending. So that I'll file an affidavit, they have to, necessary affidavit, they have to close the issues here.
The complainant has filed the application under section
already
28A of
considered
the
it.
Land Acquisition Act.
Already
to
initiated.
grant the
Proceedings is already initiated.
Because of this contempt,
Yes.
learned advocate Mr. So-and-so stated that the competent authority has already undertaken the proceedings.
Yes, please.
Under section 28.
Within
capital A
6
of the
months, please.
Land Acquisition Act 1894. And that the decision is awaited.
Yes.
Decision is awaited.
Yes, please.
Full stop.
No, no, Your Honor. There is-
Providing that the decision shall be taken as expeditiously possible, these.
My lord, I have given statement. I have given statement on 13th of this month before the authority.
Whose statement?
Accused number. The complainant has,
Pardon?
the complainant has made a statement by way of affidavit saying that why I have
But you are
entitled
seeking,
for grant
you are
compensation.
seeking some decision in 28A application.
Please, my lord.
So counsel said that proceedings are already reckoned.
Yes.
You are heard.
It's partly heard, Your Honor. It's already in the cross-examination stage.
Farid Lapo, Farid Lapo.
What,
When
please?
these contempt proceedings come up for
In
consideration.
time-bound manner,
Learned
my lord.
Advocate for the
that's-
respondent stated that
Be present
as
on the
required
record.
under the
That's
order,
That's
under the
number
order and
3, 4.
direction of learned single judge,
2, 3.
brought under the contempt jurisdiction, comma, the proceedings under section 28 capital A of the Land Acquisition Act by the competent authority has been initiated
Within,
and are underway.
yes, please. Your Honor.
Full stop. The parties are being heard.
Yes.
Full stop.
We have filed an affidavit also.
He further stated that the final decision will take take some time. What time would you want? Within 3 months?
6 months, Your Honor.
Yes.
Recently, the SLO is appointed for the election purpose. Thus, you have to pursue the annual record, which will be closed. Within 6 months, we will close it.
6
Then
months
six
is,
so is too much.
my lord, he is a senior citizen.
Within.
The land
stated
was
that the
acquired during the year
6
1993.
months time will be needed to complete the proceedings, paragraph. When the proceedings are already initiated and will culminate into the appropriate order, it could not be said at this stage that any of the respondent has committed contempt of the court, much less willful contempt of the court. Therefore, the contempt proceedings are closed by observing that the proceedings under section 28A of the Land Acquisition Act 1984 shall be concluded within 14 weeks from today. 3 months.
3 months.
More than
At
3
least 5, 15, 14 is very difficult. 28, please, I request.
We are not
I'll
the.
allow some document, maybe it's a old document, and it is a 10, 25 years document. Please request. I'm sorry, please. 20.
Yes, much of-
Contempt proceedings are accordingly disposed of.
Yes, number 30, Mr. Ganesh Kumar K.
My lordship, I am for the complaint, my lordship.
Yes.
My lordship, the complaint is working as a peon in Vidyardhaka Law College, Mysore, my lordship.
What is it about?
It's a
What direction is it? No
Direction is
prejudice
to
will be
admit
caused.
No direction, my,
Considered opinion. Impugned order was brought about just result.
page number 21, my lordship.
What is the direction?
My lordship, he's working as P1 in our Vidyardhaka Law College.
the
So
appointment
my
of the
lordship, the
peon in the
benefits under
granting
granting,
agency,
Additional advocate Mr. Jafar Shah wants time, stand over to.
my,
He
shorted
wants
by
time.
given. Please,
So
my,
it will go to 24th of July.
please,
Yes.
my lordship. Complaint.
31, Mr. Srinivas K.
Hearing complaint, Your Honor.
Pardon?
And for the accused, my lord. There is a direction to consider the representation, my lord. The accused have considered the representation, my lord, that the order at page number 40. order of the Leonard single judge.
Where is the direct?
Page 40 of the
Page.
order starts from 36 note. Operative, the page 40 of the order, my lord. Now, third paragraph, the grievance urged by the petitioner in this writ petition is with regard to release of arrears / difference of salary in furtherance of the 1992 settlement pay revision by the respondent company.
You have filed your compliance affidavit?
No, I have not filed the complaint round. They only filed the consideration. They have produced the consideration.
And how do you say that it is they are complied with?
They produced the letter. I'll file my. They produced the letter.
So then why you are wasting time if compliance have not filed and you are not able to show that
sorry,
the
no,
order is
I'll
compliant?
file my affidavit.
For what you are making submission?
Since
You
they
are
are-
simply asking whether compliance is filed. If not filed, whether you are able to show from the record that the order is complied with. Yes or no?
Yes, ma'am, there is a letter they only produced.
Let us see what.
After considering the order, they
Yes.
issued a letter, my lord,
Let us see,
communication.
where is that?
Page number 45, my lord.
45. What does it say?
It says, my lord, they have also given that 1992 pay scale is already given. They have given the representation. Earlier, they have given in 2016, they have given the
Presentation is given, the court is directed to decide, you have decided or not, that is the
They
only.
decided,
source.
my lord, decided at page number 45, 46, my lord.
45. Where is that? Read it. What is?
My lord, this honorable court, this Karnataka, why its order dated 7/6/1992 passed in WP number so has disposed of the petition, directing the respondent attempt to consider the representation.
Oh,
of the
then
petition.
what is the question?
Next week, my lord. Kindly have it on next week, my lord.
Pardon? Why?
My senior is not well, my lord. My senior is not well today.
Senior is will be unwell in this matter. Any senior will become unwell. When do you want? Monday?
Any.
At the request of learned advocate, so and so complainant, stand out to Monday at 2:30. Since it was pointed out by learned advocate, so and so for the respondent, that the representation is decided.
Ready notice matters, cell number 32, Mr. Subramania Patyam.
Appearing for the state, my lord. My lord, they have challenged the constitutional validity, but primarily with regard to maintainability of this petition, my lord, because it's a public interest litigation pertaining to a service matter.
Lord, may I
And-
just make one submission, Lord? Lord, could it be had somewhere next week, Lord? Your Lord, I request your lordship to kindly grant me week's time.
Let us.
The selection process to the KPSC has been challenged, which comes within the purview of a service matter. And public interest litigation in,
Where is the decision?
this is, I just have one copy, my lord, sorry.
So here, what is the prayer?
Only one prayer remains.
This is not in that such service matter. They want the Karnataka Civil Services Rules Act.
Policy. 2018.
Then constitute.
The Recruitment Act of 2018, which pertains to selection.
Yes, proceed.
Next week, your lordship may be kind enough to have it. In fact, note this maintainability is also not was gone into in the earlier round of petition. Lord, that has been considered in our favor. Then, my lord, there are a series of.
Now not possible.
Big lord.
You're not proceeding right now.
Today I have got some
difficult. Then it will go to 8th of July.
Please, my lord. Much obliged.
Number 33.
Appear for the petitioner in this case, my lord. There's a public interest litigation, my lord, filed challenging the Karnataka agricultural policy, my lord, 2013, stating that only through this policy, the entire agricultural market, the agricultural produce market has been open to private players in an arbitrary and illegal manner, my lord. So the pleadings are complete, my lord. The matter will have to be heard.
Pardon?
1 week time may be granted.
8th of July. 8th
Yes,
July.
Obliged. 8th July.
Number 34.
My lords, I appear for the petitioner's counsel in this matter, my lords.
Appear for the state, my lord.
Yes.
My lords, this matter relates, my lords, to the regulation, exploitation and regulation of groundwater, my lords, in the city of Bangalore and the rural areas. My lords, in the petition, my lords, we have asked for some directions to be issued in the manner in which the regulation is being done. My lords, the law requires that for every borewell, my lords, digging of borewell, there should be a license granted by the state. Now, my lords, in recent times, as your lordships are also aware, there was a severe water crisis. Now, earlier, another bench, my lords, coordinate bench had passed directions for filing of a status report, which they have filed and which they have served a copy on us last week. Unfortunately, my lords, it doesn't give the status as far as the existence of the number of borewells, number of borewells actually licensed, number of borewells unlicensed, and the steps being taken. So in that way, my lords, it is not a contentious PIL as such, my lords, but requires some directions by this court to enforce the existing principles, which the report which they have submitted doesn't actually capture that. And in fact, they go on, it goes off on another tangent altogether, my lords.
My lord, I am appearing for the state. We had filed our affidavit on 4/10/2023, detailing as to what all action the state has taken with regard to maintaining the rainwater harvesting, digging of wells in farmlands, and also the various schemes in the state of Karnataka. However, my lord, if there is anything, as the learned senior counsel mentioned, that it doesn't meet to their expectation, if there is anything they require the state to do, if they can give it to us in writing, then I could look into it and ask the officers concerned. Our report is dated 4/10/23, my lord.
My lords, a simple point in this. In fact, my lords, on the earlier occasion when the matter had come up, I think my learned friend was not present, was another learned counsel appearing. One of the questions they asked was, for example, does the state have a record of how many licensed borewells there exist in the areas? And the answer was, nobody has this information. And that's the first point of information, my lords, that they are supposed to maintain. Without it, there's no question of regulation.
Pleadings are complete.
Pardon me, my lord.
Pleadings are complete.
Pleadings are complete, my lords.
Pleadings are complete.
Finally, 9th of July.
Much obliged. ma'am.
Much obliged, my lords.
That day will.
Number 35, Gauri Shankar S, 14%.
Sir, I'm Gauri Shankar, party in person, the petition in this matter. This issue is about the corruption in BBMP, and I'm pointing out various directions from the government on the statute which is not being followed. So I've given evidences and documents for all those things. So last time, in the last hearing, my friends asked for a summary of the various observations and the prayers. So I've given them a concise summary. I filed it yesterday. So they said they will look into it and they will come back.
We have not been
Lord,
served with any
we
copies.
were instructed that they have served it at the registry.
Yeah.
So I don't have the copy of it.
We have not been served with any copies.
I did it yesterday in the counter.
You copy.
I'll give copies.
Take up on 12th of July.
Thank you. Sir.
It's
Number
12th July.
36, Avinash Gold. 36.
For the petitioner's counsel. The issue on hand is, lords. In a revision filed by the petitioner, whether the revisional authority, my lords, could go beyond the scope of revision and come to his own conclusions on a new ground. That was the issue, my lords. While issuing notice, your lordships considered that on 8/11/2023, I filed revision against an order passed by the senior geologist, my lord, suspending my quarrying operations. Now, my lords, the revisional authority, while considering my revision, my lords, goes beyond the scope and virtually says that the extension period of the lease itself is wrong and the department has to take action to cancel my lease. In a revision, my lords, he does not have the jurisdiction is one of the questions which was raised.
Where is the order of revision?
My lords, Annexure A, my lords, please come to the revisional order. My lords, the translated copy starts from running page 41.
So 46 is the order.
Yes. Now, something which is not pleaded, something which is not even confronted to me comes out in the order.
What is that aspect? Page 45.
Lords, if your lordships, see, my lords, what was questioned, your lordships should get at page 41 before the revisional authority. He records what is questioned in a revision. Running page 41, my lords. Under rule 53 of the Karnataka Minor Mineral Concession Rules, Srimati so-and-so has filed revision petition before this controlling authority on 2/3/23 seeking revision against the notice issued by the competent authority, Shumaga, under letter dated, endorsement dated 17/10/22 and endorsement dated 6/10/2022 issued by the Deputy Commissioner, Conservator of Forest so-and-so. Now he goes into that issue whether suspension, I filed the revision saying that suspension itself is wrong. Now, after going into that, now, my lords, please see. Then he comes to, at running page, my lords, 43. From 43, he goes into other issues of my extension of lease period itself. Whether it is valid or not. From running page 43, last para, my lords. Before that, in 43 second para, he says it's only an interdepartmental communication. I can't challenge that in a revision. Then from 43 last para, my lords, if your lordship gets. In this background, the application submitted along with stipulated fee seeking mineral transport license in the said lease have been kept pending, and it is necessary to immediately stop granite quarrying in the above two granite quarrying leases for which quarrying order has been issued under Dias non, and further as stated by Deputy Conservator of Forest Shumaga, it is necessary to obtain prior approval of the government as per section 2 of the Forest Conservation Act. The order of extension of period of granite quarrying lease issued as Dias non period under Rule 8A1 is not as per rules. Then he goes into that, and please come to 45 after extracting the provisions. Last para in running page 45 minutes. In the instant case, the order of extension of period as Dias non period as per Rule 8A1 is contrary to section 19 of MMDR Act 1957. Further, it is seen that the empowered authority has issued show cause notice dated 17/10/22 seeking explanation as to why your mining lease should not be cancelled. On examination of above factors, it is ordered. He upholds the order, but see the second part. As per section 19 of MMDR Act, order of senior geologist Shumaga extending the period by applying period of non-Dias revision petition number so-and-so is disposed of with a direction to issue notice, provide an opportunity to submit his case as per rules and to take steps. He could not, he should decide I go there challenging one order. It's only a revisional order. And the law laid down in the judgments, my lords, is very clear that in a revision, lords, the revisional power is limited only to check on the legality of the or the propriety of the decision, and he can't, and which is not even confronted to me. Moreover, there has been an amendment to the rules by which my lease automatically is a deemed extension for 30 years. In one hand, he says it's an interdepartmental communication, I will not entertain your revision. But then goes ahead and says, I uphold it, cancel the lease. The entire two paper books are previous litigations, and the lease deeds which have been renewed from 2001 onwards. The issue is primarily this, my lords. In 43 at page second para, he says the endorsement which I have challenged are interdepartmental communications. Revision is not meant, it cannot be entertained, and he says revision stands dismissed. Then my lords, he goes ahead and says take action to cancel the lease. That is not his prerogative at all as a revisional authority.
So what was the prayer before?
Well, the prayer was, if your lordship sees, there were two endorsements. One endorsement issued by the senior geologist, my lords, that's who's lower than the joint director.
So which is correct?
Lords,
amongst two correspondence, two letters, which was correct?
That he says it is only the senior geologist says, I suspend your mining operation, quarrying operations because the DCF has communicated something to the senior geologist. So I challenged both those letters in the revision. I came before this court. The government raised a contention, my lords, that a revisional power is there. I have to approach in a revisional. I file a revision. Now, in the revision, the revisional authority holds it's only an interdepartmental communication. So your revision is not maintainable. I dismiss it. At page 43, second para, your lordships would get that. But it proceeds further. It is not. These issues, whether Dias non extension, they are not even confronted.
Yes,
the facts are that what was challenged before the revisional authority was a show cause notice issued to the petitioner as to why the extension granted under Dias non period under 8A should not be withdrawn because it was granted on the wrong notion. In the meanwhile, petitioner approached this honorable court challenging two interdepartmental communication. That is, those are the communication written by Deputy Conservator of Forest to the senior geologist. Then we took up a contention that since revision is pending before the revisional authority, these two communications can be challenged in the very same revision. Thereafter, he approved the revisional authority challenging the show cause notice as well as two communication, interdepartmental communications. The revisional authority, after going through the papers, rightly held that the dice non-extension cannot be granted to the petitioner. Second aspect of the matter is the very quarry area is within the reserved forest, notified forest. We have filed our statement of objections. Last may kindly take statement of objections filed on 27th November 2020. Para formula, page number 2.
Page number?
Para 4. Para 4 of page number 2 of my statement of objection.
Page number
2. In the statement of objections filed on 27th November 2023.
Yes.
He submitted that, may I read the report? Submitted that the impugned order dated 26/10/2023 passed by respondent number 4, considering the revision petition in form RV filed by the petitioner on 2/3/2023. Petitioner filed said revision petition against notice dated 17/10/2022. Passed by the respondent number 6, who is senior geologist, Department of Mines and Geology of Shivamogga District. Further challenge the endorsement dated 6/10/2022, passed by the Deputy Conservator of Forest, and endorsement dated 11/10/2022, passed by the Range Forest Officer. The copy of the said revision petition is produced and marked as, this is the revision petition filed by the petitioner. It is submitted that the petitioner contended before the Honorable Court, as per the order dated 18/11/2023, that the revisional authority clearly, while considering the revision filed by the petitioner for extension of period of quarry license, exceeded without there being any power vested with the revisional authority, clearly passed an order cancelling the lease and license itself. The said submission is misleading, erroneous for the following reasons. A, the challenge before the revisional authority is the show cause notice dated 17/10/2022 issued by the competent authority, and endorsement dated 6/10/2022 and 11/10/2022 passed by the Forest Department. The operative portion of the impugned order dated 26/10/2023 passed by the revisional authority reads thus. The order passed by the senior geologist Shivamogga extending the lease period as per dice non-period, the revisional application number so-and-so is disposed of, directing the competent authority to take action as per section 19 of MMDR Act 1957, after issuing and providing an opportunity of hearing. This was the order passed by the revisional authority. It is evident from the above, the revisional authority upheld the notice issued by the competent authority. Further, so far as cancellation of granted leases under dice non-period is concerned, the matter remitted back to the competent authority, respondent number 6, hearing. There was no decision taken by the revisional authority. He has remitted the matter back to the competent authority to decide on dies non period after affording an opportunity to the petitioner. That is what the order of the revisional authority is. Further, my lord, may I continue reading?
Tomorrow or any other day?
Please.
Tomorrow.
Subject to my lord.
My lord, one submission.
Lordship, serial number 41, serial number 41 is with respect to educational matter, my lord. With respect to OCI citizens, medical counseling might start up anytime, my lord. Kindly have it done.
8.
Please.
My lord, one
8th of
submission.
July.
My lord, tomorrow or day after tomorrow, my lord. Forty-one. Respect to OCI category students, my lord.
When do you want?
My lord, tomorrow or day after tomorrow, my lord.
Day
Your
after.
lordship may please.
Yeah.
Please, my lord. Grateful, my lord.
Lord,
Grateful.
serial
Who
number.
is opposing you, Mr.?
Lord, Mr. N.K. Ramesh, my lord. We have served a copy. Your lordship may, I'll get him today itself, my lord.
Oh, that's C371J.
No, my lord, I'm not claiming any reservation, my lord. It's a general category I'm claiming, my lord.
Not claiming any reservation.
No, my lord, I'm not claiming any reservation, my lord.
Then it is simple, covered.
Please, it's already covered by divisional bench of order of this court itself, my lord.
Well,
Same interim what I'm.
Day after.
Please, my lord, much obliged.
My lord,
My lord,
serial
serial
number.
number 60
You are
and
seeking
connected.
interim order.
For the interim order.
Day after.
My lord, one submission, my lord. Can it be taken on top of the list, my lord? My lord. Top of the list, my lord.
You mentioned, remind us.
Please, my lord. Grateful.
My lord,
Serial
serial number
number
60 and
47.
connected matters, my lord, and serial number 71 may kindly be adjourned to next month, my lord. Interim order be extended till next month.
Is pertaining to many wages.
No wage matter, my lord. May be taken on 26th of this month, my lord. Some urgency, my lord.
Which one?
26th of this month would be 20.
That's the one what
Connected
we were asking.
matters.
One, yes.
My lordship, serial number 44, my lordship. So next week, maybe, lordship, my lordship.
What is the matter?
There is a LABDA, my lordship, there is.
Then let it go 8th of July, yes.
Serial number 38, my lord. The BBMP is not taking any action, illegal display of the elected MLAs. It is inconsistent with this order of this honorable. court
Illegal
as well as Supreme Court
display of what?
Display of elected MLAs. It is restricted only to the ministers. It is covered by order by this honorable court, my lord. in my
Display of?
petition. I have
My lord,
I have produced the
Display of hoardings.
serial number 38, my lord. BBMP has not complied.
Unless you display what is display, we are not going to. Yes.
My lord, display, it is inconsistent to the Supreme Court. Honorable
Display
Supreme
of what?
Court. MLAs, elected MLAs.
Ah, that PIL.
That it has been restricted by the Honorable Supreme Court as well as this Honorable Court has given direction to remove all such illegal display of MLAs and MLCs, MPs.
Now there is no election.
Covered by order is there. Next week it may be taken.
10th of July.
Serial number 60, my lord.
Lordship, item number 64. This is an elephant matter. Copies have been
60 onwards.
On 29.
26th or 4th, my lord.
Interim order.
4th would be ideal, madam.
4th may be.
4th of July would be ideal.
All
Connected matters.
Fourth.
4th of.
Serial number 71 also.
That's
madam.
My lord, 4th at 2.
Who is meant? You are.
Yes, my lord.
Which matter? What is it? Group?
Lordship,
Yeah, group matter.
Group matter, my lord. Connected matters are there.
My lord, batch of. 4th of.
27th.
Fourth, July, my lord. Senior counsel, sir.
4th July.
2:30, my lord.
3rd July.
3rd.
Or 5th July, better. Best is 5th July.
5th July.
5th July.
Lordship's permission.
may I, Lordship?
My lord, at 2:30, my lord, because it's a minimum wage matters, some lakhs of workers are involved in this matter, my lord. We are suffering from almost 1 year. At 2:30, my lord.
Will be there or not?
I will be here.
Then will be also here, yes.
Serial number
May I, Lordship?
Serial number 78.
49, my lord, it involves lot of senior citizens, my lord. Salaries have been executed. Supposed to reply, my lord, there is a direction by the honorable. Not to take it up day after tomorrow. Monday,
What is that? urgency?
my lord, here there are 49 salaries have been executed in favor of the senior citizens. My lord, the government was asked to give their reply on about 1 month back.
Monday.
Time for the writ petitioner in the connected writ petitioner. Interim order has to be extended.
Interim order will extend.
Appear for the accused in that matter, my lord. Serial number 78, my lord.
And may I
As from
request-
1.5 year, my lord, he has been dismissed from service. My lord, state has come up for appeal, my lord. That is the reason, my lord.
Will take up what can be.
Maybe I
done.
have.
But that
Day
matter-
after.
Day after.
78.
Why not today?
State in the self center.
but that matter on the 25th. 49, 25th, not 24th. 25th.
Serial number. Serial.
8, my lord. There's a matter where I've been terminated from service. The series of Cooperative have been terminated from service at Groundwater, my lord. Anytime this week, a date may can be granted, my lord.
Anytime you want. Yes.
My lord, serial number 78.
Hello?
There is urgency in it. So the last from 1.5 month, he has been dismissed from service, my lord, where the single,
Senate court officer will give the date.
but central government.
Whatever we
has
say, you will not be bind, it will not bind. Whatever we say will not bind you. You give your own date. Yes, now we are saying to everybody, but we will not bind you. Yes.
56.
Yes. Tomorrow you want? Tomorrow?
My name is Ranganath. I am defending. I am defensive.
So what do you want?
I want to early date.
Early date, all right. Given, early date is given. Yes.
Serial number 62.1.
Yes.
It's a
My lord,
recall application, my lord.
My lords, I appear for the petition.
The appeal was dismissed for tomorrow.
Tomorrow.
My lords, I appear in 62. My lords, it may be deconnected with 62.1.
My lord, serial
You
number.
give
My
in
lord.
your own way.
62, my lords.
Yes.
Serial number 71.
Tomorrow?
Is connected to serial number.
Tomorrow you want?
No, my lord. It may kindly be posted on 5th of July.
Milord 64. Milord 64.
My lords,